Alright? Line bilang tayo amin. I am from Baguio City. We drove all the way from Baguio last night to be here with you this morning. And we have half the bus, 1, 2, 3, 4, 5, 6 shells. So it looks like we have covered 12 plus 1. My name is David Law. I'm not sure if you have heard about his name before. From A to C. It's a long name. This is my family name. That's just my family name. My first name is longer than that. I have dual citizenship. I am a Filipino citizen and a senior citizen. As a Filipino citizen, I am entitled to vote. As a senior citizen, I am entitled to some discount, 20%. I come from my school in Baguio City, known as the University of the Cordillera. Its old name is Baguio College's Foundation. Now the University of the Cordillera. And this is the only school outside Metro Manila that have the bar exam but one first place. The dean of this school has a name similar to mine. Alright? So I was asked to give a lecture on two subjects in revision law, criminal procedure and evidence. That was the assignment given to me. At first, it was only criminal procedure, but last night I was told to include evidence. Alright? So, first of all, let's talk about jurisdiction of courts in criminal cases. But you know that when the word jurisdiction is mentioned in criminal cases, it involves the following aspects. So you have jurisdiction over the offense, over the person of the accused, and over the territory. Alright? And of course, all of you know that the place of the commission of the offense is what? It is also jurisdictional. So a proper venue involves jurisdictional consequences in criminal action. So let's talk about the first one, jurisdiction over the offense. And so the question is, in the bar exam on Sunday, over what offenses may the FTC exercise jurisdiction? FTC. when we say MTC in our discussion this morning, we include what? The MTCs in municipalities, and they are called what? Municipal trial courts. But there are certain towns that have only one MTC, like in La Union, for example, in La Union, Bogo and Cubao, in our two municipalities in La Union, they have only one MTC, and it is called what? The Municipal Circuit Trial Court. But in cities, like the city where I come from, Baguio City, it's called Municipal Trial Court in cities. If there's only one, you will have to say Municipal Trial Court in cities. And if there are two or more, then you say Municipal Trial Court in cities. It's always cities. Alright? And in Metropolitan Manila, they're called Metropolitan Trial Court. But every time we say MTC, unless we so specify, we mean all of them. Alright? Every time we say MTC, unless we so specify, we include all of them. And so the question is, over what offenses do MTCs exercise jurisdiction? Then over the following offenses. Number one, violation of municipal or city ordinances. Okay, so violation of municipal or city ordinances. Then the second one, over all offenses where the penalty prescribed by law, regardless of the amount of the fine, does not exceed 6 years of imprisonment. Does not exceed. Regardless of the amount of the fine. Alright, so you just have to look at the penalty. My pen. We have a technical problem. So here, on 10. So you just have to look at the penalty involving imprisonment. Alright? Now, so that if the penalty for the offense exceeds 6 years of imprisonment, like 6 years and 1 day, for example, then that will now what? That will now fall within the jurisdiction of the regional trial court. Very easy to follow. So if it does not exceed 6 years of imprisonment, then it should be filed with the MTC. And if it exceeds 6 years, suppose it is exactly 6 years, then that does not exceed. Alright? So this time, 1 day is very important because it will change what? The jurisdiction of the court. Alright? Very easy to follow. But then, I'd like you to take note of the following. So even as we say that if the penalty for the offense committed exceeds 6 years of imprisonment, that will now fall within the jurisdiction of the RTC. I'd like you to take note of the following. Number one is libel. What is the penalty for libel? I'm not talking about the Cyber Crime Prevention Act. Do you know this one? Republic Act 1017 Okay? I'm not talking about that. I'm talking about libel as penalized by the revised penal law. So the penalty is what? From 6 months and 1 day to 4 years, 2 months. So that's the penalty for libel. The maximum is what? 4 years, 2 months. And yet, that falls within the jurisdiction of the RTC. Although it does not exceed 6 years of imprisonment. So if they would ask you a question by way of an MCQ on Sunday involving jurisdiction, and then it tells you something about libel. And as you can see, the penalty for libel is what? The maximum is 4 years and 2 months, and then it falls within the jurisdiction of the RTC. And then you have also the following. Infringement of copyright and trade name. What is the penalty? From 2 years to 5 years. That's the penalty. And offenses involving what? Infringement of copyright or trade name falls within the jurisdiction of special commercial court. But if not in the place where the crime is committed, it will be the regional trial court. And then you have also what? Election offenses. What is the penalty for election offenses? From 1 to 6 years. And then they fall within the jurisdiction of the RTC. And then you have also offenses involving minors. Alright? So, the offended party is a minor, or the accused is a minor, or one of them is a minor, then the case should be filed with the family court. But if not in the place where the crime is committed, it should be filed with the regional trial court. Like here is a person only 12 years old, and then his last an old woman. He commits what? What crime is committed? Can be unjust fixation, can be slight physical injury, can be maltreatment, a minor offense, and death, because the accused is below 18 years of age. Right? Alright? Or the age of the offender is over 15 but below 18, you will have to file that with the family court. If not in the place where the crime is committed, then you file it with the family court. Alright? Are you still with me? Very good. Mine, 10. Mine. Mine. Alright? And then you have also drug-related offenses. Then you file it with the RTC. Drug-related offenses. In fact, they should not be difficult to remember. But you just have to take note that lawyers don't lie. Lawyers don't lie. But MPs do lie. But you know about MPs? You don't know. But lawyers don't lie. Everyone does end it up. You know what epitaph is? On the book. Alright? And there is this one written on the book. It says, "Here lies a lawyer. He is still lying." So we come on. Here lies a lawyer. He is still lying. So it doesn't be asked in the bar exam, fill in the blank. Here lies a blank. Lawyer. He is still blank. Right. Yeah. So the bar exam is very easy, diba? Okay? So take note of this one. Alright? Now, what about if the accused is a government employee and he commits an offense in relation to his office? So don't forget that phrase. He commits an offense in relation to his office. Okay? Then you have to look at the law that defines the jurisdiction of the Sandigan Bayan. And this law is Republican 8249. And if you go to section 4 of Republic Act 8249, then you will see a list of offices or list of public officers triable by the Sandigan Bayan. Like the mayor, the vice mayor, the governor, the vice governor, members of the Sangguniang Panlalawigan. You know what I'm talking about? Etc. You look at section 4. Then if let's say here is your client, is your client, he comes to you, and then he tells you that he is the mayor of a certain city, and then he commits an offense in relation to it, then he should be tried by the Sandigan Bayan. Alright? Let us say that here is a public officer or a government employee, and then he comes to you and he tells you that he has committed an offense in relation to his office, and then he tells you his position, and then you look at section 4, as you could not find his position among those mentioned in section 4. You know what I'm saying, class? You don't see his position among those mentioned in section 4. Then he will be tried by the Sandigan Bayan, notwithstanding that his position is not among those mentioned in section 4. If his position is equivalent to what? To grade 27 or higher under the Compensation and Position Classification Act. Hello? So if you look at section 4, if his position is not among those mentioned, but he occupies a position equivalent to grade 27, salary grade 27 or higher, then he will be triable by the Sandigan Bayan. You understand? You understand? Let me give you a problem. Here is a member of the Sangguniang Panlalawigan. Hello? And his position is only salary grade 26. That is the classification. Yung mga members of the Sangguniang Panlalawigan. And then he commits an offense in relation to his office. What court will try him? Can he be tried by the Sandigan Bayan or not? The answer is what? He should be tried by the Sandigan Bayan. Because although his position is only salary grade 26, his position is among those mentioned in Section 4 of Republic Act 8249. Understood? Okay, now, let us say that here is Y. He is a government employee and he commits an offense in relation to his office. But his position is not among those mentioned in Section 4, and he is not also salary grade 27 or higher. What court will try him? Answer: he will be tried by the RTC or by the MTC, depending on what kind of offense he has committed. If the penalty for the offense he committed does not exceed 6 years of imprisonment, then he will be tried by the MTC. And if it exceeds 6 years of imprisonment, he will be tried by the RTC. You understand? Now, here's something I'd like to tell you. Let us say that a government official is triable by the Sandigan Bayan. Question. In determining whether or not he should be tried by the Sandigan Bayan, is the penalty material? Do we have to look into the penalty? The answer is no. If, let us say, his position is mentioned in Section 4, or even is not mentioned, he occupies a position equivalent to grade 27 or higher, he will be tried by the Sandigan Bayan regardless of the penalty. Understand? But if he is not there, and he is triable by the regular court, then whether it will be the RTC or the MTC will depend on the penalty. I hope you understand those. Alright? Question. So here I told you that it is not enough that the court has restriction over the offense. It is also important that it must have jurisdiction over the person of the accused. And the question is, how may the court acquire jurisdiction over the person of the accused? Do you know the answer? In one of two ways. Number one, by his valid arrest. And number two, what's number two? By his voluntary appearance. Okay? Voluntary. But how the court acquires jurisdiction over the person of the accused. Alright? So you just have to take note of those. Question. Is that the same as in custody? You know what I'm saying, class? Alright. If a person is charged in court with an offense, and then he would like to post bail, then he cannot post bail unless he is in the custody of the law. Hello? Now, question is, how may a person be said to be in the custody of the law so that he can post bail? Answer, by his valid arrest, or number 2, voluntary surrender. Okay? So take note that in custody is not the same as jurisdiction over the person of the accused. I hope you can see the distinction. Can I post bail even if I'm not in the custody of the law, I am in hiding? No, because if I'm not in the custody of the law, my liberty is not restricted. I am a free man, so to say. So I need to be in the custody of the law so that I can post bail or I can file an application for bail. Alright? Now here, let us say that a case is filed against me for kidnapping, for example. And then I learned that a case was filed against me for kidnapping. I am in hiding. I will not surrender. I am not arrested. Alright? And then I looked at information that was filed against me, and I noticed that the information does not charge an offense at all. Can I file a motion to quash on the ground that the past charge do not constitute an offense, even if I am not in the custody of the law? Can I do that? The answer is yes. The only time when the accused should be in the custody of the law to avail himself of any of the remedies is when he will post bail. Okay? We will talk about that some more as we move along. But meanwhile, I'd like you to understand that there is a distinction between in the custody of the law and the what? Acquiring jurisdiction over the person of the accused. Just to emphasize the difference, let us say that I was charged with an offense. Alright? Like what? Like what offense would you like to charge me with? Like rape. Okay. So I was charged with rape. I was arrested. Okay. And then I was arraigned and pleaded not guilty. In the dead of night, I escaped from the city jail. I escaped. And the police could not locate me. Question, am I in the custody of the law? During the period that from the time I escaped, up to the time I will be arrested, for example, I'm not in the custody of the law. But the court has acquired jurisdiction over my person. So it is possible for the court to acquire jurisdiction over the person of the accused, although the accused is not in the custody of the law. You understand it now? Okay. And then we go to the third one, jurisdiction over the territory. I told you a while ago that venue is jurisdictional in criminal cases, unlike in civil cases. You understand? Because in a civil action, self-defendant may even waive improper venue. It has to waive. But in criminal action, the venue is also a matter of jurisdiction. Okay? And so, I'd like you to pay attention to this one. The question is, where should the criminal action be instituted? Then you have to be guided by the following. Number one, the criminal action should be instituted, alright, in the court of the municipality or territory where the crime is committed, or any of its material ingredients occurred. So where the crime is what? Committed. Or any of its material ingredients occurred. The last part deals with what is known as continuing crime. Alright? Okay? And then number two, where the crime or where the offense is committed on board a what? A train, an aircraft, or a vehicle, public or private. Then the criminal action should be instituted in the court of the municipality or territory where what? The train, aircraft, or vehicle passed during its trip. Okay? Including the place of departure and the place of arrival. So, that happens when the offense is committed on board a train, aircraft, or vehicle in the course of its trip. You know what I'm saying, class? Then, the criminal action should be instituted in the court of the municipality or territory where the train, aircraft, or vehicle passed during its trip, including the place of departure and the place of arrival. So let's say that or from Luzon, from the Visayas, from Mindanao. I am from Luzon. I am an Ilocano, but my father was from Iloilo. So I am a Visaya Ilocano. Okay? But in Baguio, if you'd like to come down to Manila from Baguio coming down to Manila, you could take a bus. This is the bus. Alright, leaving Baguio, and then you pass through so many provinces like Pangasinan, La Union, Pangasinan, Poder, yes, Pampanga, Bulacan. So let's say that when the bus was in La Union, this one is a bus full of passengers. When the bus was in La Union, it departed the rate W. while the bus was in London. And then the race went on until the bus was in Pangasinan. And then the race ended in Pangasinan, but the bus proceeded all the way up to Manila. Question: can you find the gate in Manila? Of course, that is the place of arrival. Can you find the gate in Baguio? Yes, also. What about in Bulacan? Also, yes. Any of the municipalities or territories where the train, aircraft, or vehicle pass in the course of the trip. Then the third one, when the offense is committed on board of vessel in the course of its voyage, then the criminal action may be instituted in the court of the first port of entry or in the court of any of the municipalities or territories where the vessel passed in the course of its voyage. And then number 4 is what? Where the crime or offense is committed outside the Philippines, but triable in the Philippines, under Article 2 of the Revised Penal Code. Then, the court in which the case is first filed will take cognizance of the case. John, just take note of this one. Very easy. Except that, if you would be asked a problem, it might not be very easy. But, yung mga standards like, I shot and killed a person in Baguio. Where will I be tried? Of course, in the court in Baguio City. I kidnapped Abe in Baguio and then brought him to Leyte, from Leyte to Jenpa, Jenpa to Makati, Makati to Tabuk, Tabuk to Banawe. Question: where can you file the case against me? In the court of any of these places. You understand? Okay. Yung mga yun, giveaway questions yun. Ito ngayon ang hindi giveaway. Yeah. Here is, you know, this one is La Trinidad. You know La Trinidad? You don't know? Okay. This one is Baguio. Baguio. La Trinidad is in Benguet. Baguio is a city adjoining La Trinidad. Although you probably wouldn't know if you are already in Baguio or you're still in La Trinidad. Have you been to Baguio City? Yes. If not, you after the work class, go to Baguio, and then call me up, I'll bring you around. No charge to you.
Recorded. Now na daw.
Okay, now, you're filing a case in Baguio, RTC Baguio. It is the plaintiff filing a case in the RTC of Baguio. You know complaint? You want to attend to the complaint, certification against forum shopping. Or you can say certification on non-forum shopping. But never say certification against non-forum shopping. Don't say that. You know what I'm saying? Okay. Now, suppose you make a false certification on non-forum shopping. Do you know that that is supposed to be under oath? And if you make a false certification, you commit an offense called perjury. You understand? How do you commit perjury? In one of the two ways of committing it, one is by falsely testifying in any proceeding other than criminal or civil. If you falsely testify in a civil action, then your crime is false testimony in a civil action. Diba? Did you learn that in scriptural law? If you falsely testify in a proceeding other than civil or criminal, like in an administrative proceeding, then you commit perjury. That's one way of committing it. The second way is what? By giving a false affidavit. By executing a false affidavit. A sworn statement. Yeah. So let's say that here is X like A. He is from La Trinidad, but he's filing a complaint in Baguio City because the location of the property subject of the case is Baguio City. And then he executed a certification on non-forum shopping in La Trinidad. And that is a false certification. It contains false statements. And X knew them to be false. You know what I'm saying, class? And then the complaint was filed in Baguio City. Artiso Baguio City. Question: where do you find the criminal case for perjury? Is it Baguio City or La Trinidad? See, medyo hindi na madali yan, di ba? Yes, class. La Trinidad. Okay? You understand? Because the crime was committed in La Trinidad. That is where the crime was committed. Okay? Ngayon, do you know that in some instances, you can simply submit an affidavit, and that will be your testimony? You know what I'm saying, class? Like, let's say that here is a labor case filed in Baguio City. It's a labor case filed before the labor arbiter in Baguio City. Can you understand what I'm saying? This one is an administrative case. As you know that you have to submit a position paper, and you can also attach to it an affidavit. And then let us say that X executed an affidavit in La Trinidad. Okay? And then that was submitted to this labor case in Baguio City to be his testimony. You understand? Question: where can you file the case now? Is it in La Trinidad or in Baguio City? You know, there are two ways of committing perjury. See? The first one is what? By falsely testifying in a proceeding under the civil or criminal. Ito ngayon, yung affidavit made in La Trinidad was submitted in this case in Baguio City to be the testimony of it. Can you understand the problem? Question: where can you file the case now? The answer: you file it either in La Trinidad or in Baguio City. Because what? The element of execution happened in La Trinidad, but the elements of testifying happen in body. So you have to distinguish this problem from the first example that we have. Alright, then we go to the next topic. We are staying here up to when? Up to what time? Up to... I need to know so I can assemble my topics in my mind. Do you have any topic you want to be discussed? You have or you don't have? If you don't have, I'll just ramble along. So here I'd like to talk to you about what? About amendment. Amendment of a complaint, amendment of an information. As you know that in criminal cases, amendment may be substantial or formal. Okay, so you have substantial amendment, you have formal amendment. Okay? If the amendment changes the nature of the offense, or it requires the presentation of a more burdensome evidence, or it affects the jurisdiction of the court, then that amendment is substantial. Otherwise, the amendment is only formal. But then, look at this one time. There are times when amendments should be with leave of court, and there are times when there is no need to obtain leave of court. Okay? Now, if they would ask you a problem or a question in the verse involving amendments, then you should be guided by the following rules. If you can follow this one, you have no problem. Okay? So the verse is what? Before sleep. Before sleep. What do you mean by before sleep? Before the accused enters a plea. For a plea, it can be a plea of guilty or a plea of not guilty. It does not matter. So before the accused enters a plea, the complaint or information may be amended as to form or substance without leave of court. Without leave. So you don't need leave of court. Hello? Alright. Before plea. What kind of amendment can you make before plea? Substantial amendment, formal amendment. And there is no need to obtain leave of court. Okay? Then, number 2, after plea. The complaint or information can be amended only as to form, only formal amendment, and even so, there must be leave of court. So the only amendment that you can make at that point is formal amendment, and even so, there must be leave of court. You understand that? Okay. The next one, before plea. And the purpose of the amendment is to downgrade the nature of the offense, or to exclude and accuse from the complaint or information. Then the amendment should be upon motion of the prosecution with notice to the offended party and with leave of court. That is the fourth thing. But what is the purpose of the amendment? To downgrade the nature of the offense. Like, downgrading plan? Like from rape to unjust dictation. So far away, from murder to homicide, not downgrading. Okay? Then, you need, the prosecution must file a motion for leave comment, and there must be notice to the offended party, because the offended party has the right to oppose or to receive the motion. Alright? And then there must be leave of court. And the same thing can be said if the purpose of the amendment is to exclude an accused from the complaint or information. These presupposes that there are multiple accused. Like the people of the Philippines versus A, B, and C. And the purpose of the amendment is to exclude A from the information or complaint. Okay? That is not the same as discharging an accused to be utilized as a state witness. We will talk about that later on. And then the next one is what? Next one. Thirdly, and the amendment is by reason of a supervening fact. Alright? Then that is a substantial amendment. But notwithstanding that it is a substantial amendment, it can still be made. Because the amendment is by reason of what? Of a supervening fact. Provided there is leave of court. So this one, you need leave of court. Like what? Like I shot a person between the eyes. I do that every day. Very good. Look, that's really to wake you up. So I shot a person between the eyes. And then he was brought to the hospital. He did not die. In the meantime, there was a case filed against me for frustrated murder. And then the person still did not die. And so we went to trial. I pleaded not guilty. And then the first witness was presented against me. Still that person did not die. And then when it was my turn to present evidence, he died. Finally. Question. May the prosecution amend the information to charge me with murder? Yes, because the death of the victim is a supervening fact. But there must be leave of court. You understand that? Okay. Very good. Well, let us say that X was charged with homicide. So this one is X charged with what? With homicide. Alright? What's the penalty for homicide? Reclusion temporary. From 12 years and 1 day to 20 years. Alright? Okay? X was arraigned. He pleaded not guilty. And then after X had pleaded not guilty, the prosecution wanted to amend the information to include the aggravating circumstance of dwelling. A generic aggravating circumstance. You know what I'm saying, man? Question. May the prosecution still amend the information to include a generic aggravating circumstance of dwelling? Oh. You understand the problem? Yes, the problem. Do you understand? Okay. What do you think? X pleaded not guilty. Not guilty. After he had pleaded, the prosecution would like to amend the information. Question. Can the prosecution still amend the information? If so, does it need leave of court? That's going to be problem number 41 in the bar exam. Essay. I heard that in fact, that teaches you have 35 problems all in all. This one is number 41. Yeah, so if that would be given back, then the answer is yes, the prosecution can still amend this information. Why? Because that is only a form of amendment. But here, formal, there must be leave of court. Formal. Ngayon, what is the test to follow? So that when a problem is presented, you can easily answer it. What's the test? The test consists is what? An amendment to include a generic aggravating circumstance is only formal because it does not alter the penalty prescribed by law. Now look at this one. What is the penalty for homicide? From 12 years and 1 day to 20 years. Suppose you include that generic aggravating circumstance of dwelling. What is the penalty? It's still from 12 years and 1 day to 20 years. Meaning you will not go beyond 20 years. You know what I'm saying, class? Then the test is this one. That if the amendment to include an aggravating circumstance will not alter the penalty, like in the example given, then the amendment is only formal. Of course, it will affect the computation of the penalty when you come down to the indeterminate sentence law. You know what I'm saying? But it will not have the effect of going beyond 20 years. It will not alter the penalty. Okay? But suppose it will, it is not dwelling but what? But evidence premeditation. Yeah. You can decide that that is a substantial amendment because it will change the nature of the offense and the penalty will become higher. This time it will be murder. And the penalty will now be reclusion perpetua. Yeah. Suppose they would ask you a question like, does an amendment to correct the date of the commission of the offense formal or substantial? Can you understand the question? Does an amendment to correct the date of the commission of the offense formal or substantial? Like the date was July 16, 2012, and then you will amend that is the date mentioned in the information, and then you will now amend it to correct the date from July 16 to July 29, 2012. Because when you look at the evidence, the crime was committed July 29, 2012. But what was the statement in the information is July 16. Question. Is an amendment to correct the date of the commission of the offense formal or substantial? The answer, class, formal. Except if the date is an element of the offense. What is an example? It has to time. Okay? When is it satisfied? When the victim killed is less than 72 hours old, that is satisfied. You know what I'm saying? And then you will change the date. Then it will not anymore be satisfied. So the underground term is only formal, except when the date is an element of the offense. In which case, that will not be substantial. After all, you learned, I'm sure, that in mentioning the date, you don't really have to be very exact as to the date of the commission. The point, in most, if not all, complaints and information, you can see the word or the phrase on or about. So that is, let's say, you say on or about the 16th day of July, 2012. And then the evidence that you presented proves that the crime was committed on another day, then that will not affect the validity of the complaint or information. Okay? That's why they always include the phrase on or about. I hope that we have what I'm saying. Any questions? So take note of this principle involving amendment. Right? Amendment is not the same as substitution. Substitution of a complaint or information. Substitution. Not the same as amendment. Alright? What is the rule of substitution? Then the rule is as follows. When it appears at any time before judgment. Yeah. When it appears at any time before judgment, that a mistake has been made in charging the proper offense. And the accused cannot be convicted of the crime charged, cannot be convicted of the crime charge. Then the court shall dismiss the complaint or information after allowing a new one, and should allow a new one to be filed. This time charging the proper offense. You understand? That is not amendment, that is called substitution. Just take note of the following. It appears at any time before judgment that a mistake has been made in charging the proper offense, and the accused cannot be convicted of the crime charge. Then what should the court do? It shall dismiss the complaint or information and allow the filing of a new one. Okay? Look at this one. Is it, let's say that will be given a problem in the bar exams this coming Sunday, and then the question is this amendment or substitution? Yeah. Then you should be guided by the following text. That in substitution, a mistake has been made in charging the proper offense. You understand? Look at this one. In criminal law, You learn that sometimes it is not easy to tell if the crime committed is death or the papa. Diba? So there are times when it is not easy to tell. So let's say that here is the people of the Philippines versus him. He was charged with death. And then he pleaded guilty, he pleaded not guilty, and then he went to trial. They went to trial. The prosecution presented evidence. But based on the evidence presented by the prosecution, it was seen that the crime committed is his papa. Okay? The charge against him is what? For death. But the evidence will show that the crime committed is what? Papa. Then look at this one. If it appears at any time before judgment, God. That's what a mistake has been made in charging the proper offense. Question here. If the charge is death, but the evidence would show that the crime committed is Papa, may the accused be convicted of the Papa? No. Because that is not the crime charge. You will violate his right to be informed of the nature and form of the accusation against him. If you will convict him of his Papa, because he was arraigned for death, you understand? Then look, can he be convicted of death? So also because the evidence will show that the crime committed is what? His Papa. So here, you cannot convict the accused. If it appears at any time before judgment that a mistake has been made in charging the proper offense, and the accused cannot be convicted of the crime charge, then what will the court do? It will dismiss the information or complaint. Does it mean that the accused is now home free? No, because the court will allow the filing of a new one, this time charging the proper offense. Question: is that amendment? No, sir. That is not amendment. That is substitution. You follow? Look. Question: is it easy to tell if it is amendment or substitution? Very easy to tell. Look at this one, class. This one is amendment. This is the original complaint or information. This is the amended complaint or information. Okay? In amendment, the offenses are the same. Same, homicide, homicide. Or what? The amendment includes the offense charged under the original information, like this one is homicide, this one is murder. Or this one is murder, this one is homicide. Hello? So it's the same act. Alright? It's just my background. And therefore, in amendment like in number 2, okay? Let us say that the accused has already entered a plea. He pleaded not guilty. And then you will amend information in a substantial way. Question: are you violating any of his rights? Yes, you violate his right against double property. Right. This one is homicide, then you make it murder. Okay? And if the court grants leave, then that is gross ignorance of the law. Done. Okay? So in amendment, there is a possibility of violating the rights of the accused against double jeopardy. You know what I'm saying, Ron? But in substitution, double jeopardy will not step in. You know why? Because the offenses are different. So if you see in the problem that the offenses are not the same. The offenses are different like what? Like theft and papa, that's not amendment, that is substitution. Okay? Any question? Anything you'd like to discuss?
Possible na lalabas sa bar, sir.
Ayan, possible ha? Alright, you know, preliminary investigation. That is who can apply for preliminary investigation. You have the number one, the city or provincial prosecutors for their assistance. And then the regional or state prosecutors, okay? And then the third one, what's the third one? Other officers as may be authorized by law. Like who? Like the one is other officers as may be authorized by law. Okay? Like who? Like the PCGG in cases involving ill Commonwealth. Like who? Like the Commonwealth with respect to election offenses. And also the Ombudsman with respect to what? To offenses committed by government officials in relation to their office. Okay, now look. Question is, when can there be what? Preliminary offense investigation. What offenses require preliminary investigation? The answer, only offenses where the penalty prescribed by law, regardless of the amount of the fine, is at least, take note of the word at least. At least 4 to 1. But in the bar exam, do not say 4 to 1. You say at least 4 years, 2 months, and 1 day of imprisonment. Why do we say 4 to 1 now? For easy recall. 4 to 1. At least 4 to 1. 4 years, 2 months, and 1 day. Then there must be what? Preliminary investigation. They can easily ask this one in an MCQ, diba? So, there must be a preliminary investigation if the penalty for the offense is 8. More than 4 years, 2 months, and 1 day. Yeah. Number B. More than 6 years and 1 day. Yeah. C. At least 4 years, 2 months, and 1 day. D. At least 6 years and 1 day. Then the other class is C. When you don't know, you say C. When you don't know. But don't leave it blank. Don't leave it blank. Same thing, don't leave anything blank for your sake. It's not for heaven's sake. What should you leave it blank? If you alive. Yeah. But at least 4 years, 2 months of other. Now look, suppose the crime committed is outside. Should there be a PI? Of course, because the penalty is what? Reclusion temporal. And you're only looking at least 4 years, 2 months of one day. But suppose no PI wants to that end. What is the remedy of the accused? To file a motion to quash? No, because lack of PI is not a ground in a motion to quash. What should be the remedy of the accused? Remedy of the accused is to file a motion for the suspension of the proceedings and to direct the prosecution to conduct a preliminary investigation. But look at this one part. If the accused will not claim that right, and then after his arraignment he enters the plea, then he waives that objection. He waives that objection. You understand? So here, you need to know the grounds in a motion to quash. It is so easy to memorize. Motion to quash. Grounds. You should be guided by the following letters. Then the first one is, you say fact. The fact charged do not constitute as offense. Then the next one says, the court has no jurisdiction over the offense. And then the next case, the court has no jurisdiction over the person of the accused. And then, the officer filing information has no authority to do so. And then C, the complaint or information does not substantially conform to the prescribed form. And then X, that the complaint or information charges more than one offense, except in those instances where the law prescribes a single punishment for various offenses. And then E, that the criminal offense or criminal liability has been extinguished. And then F, that the complaint or information contains a verdict which is true constitutes legal excuse or justification. Then you say the last one is double jeopardy. But you can say that the accused has been convicted or acquitted, or that the case against him dismissed or terminated without his express consent. Double jeopardy. Okay, question. You count them if you're right, then you're correct. Can you memorize that in 10 seconds? And then you will never forget them until the bar exam is over. Of course, there's a way of doing it. In my case, I use 40. You know 40? 40 ways of doing it, but it helps. I say, I write a poem or a line using all those letters. As I say, the following. For James and John, only Christ merits exclusive loyalty and devotion. Then remove all the and. For James and John, only Christ merits exclusive loyalty and devotion. Let's say Amen. Let's pass the bar exam. Because if you memorize the letters, you will not go anywhere. But if you write a poem, then it will be there all the time. You can't recall it all the time. But then know that James and John are brothers in the New Testament. They are the sons of Zebedee. Okay? Then you even have a Bible lesson. Alright? Now look around. Using this, motion to quash. Question. When may the accused move to quash? When? The answer, at any time before he enters the plea. That's when he should move to quash. Next question, suppose he enters the plea without moving to quash. Then what happens? Then all these objections are waived. If he does not move to quash as he enters the plea, then he waives the objection. Except this one, and this one. These are grounds that are not waived, even if not set up in a motion to quash. You understand? Oh. So what happens if the accused does not move? When should the accused move to quash? Before he enters a plea. Suppose he enters the plea without moving to quash, then he waives this objection. Except F, J, E, D. These are not waived, even if not set up in a motion to quash. Is that clear? Okay. That's why, let's say that trial is now ongoing, and then the accused files a motion to quash invoking J. No restriction over the offense, can he still do that? Yes. Because that is one ground that is not waived, even if not set up in a motion to quash. Next question. What happens if the court, what happens if the accused moves to quash? He files a motion to quash. It should be in Friday. Okay? So here is the motion to quash. What will happen to his motion? Well, it may be granted or it may be denied by the court. So the motion to quash may be denied or may be granted by the court. What is the remedy of the accused whose motion to quash is denied? The answer is to enter a plea and go to trial. That is the remedy of the accused. To enter a plea and go to trial. But don't ask, what is the remedy of the accused whose motion to quash is granted by the court? Walang ganon. Yeah. Okay? But look, what will happen if the motion to quash is granted? Then the case is dismissed. Diba? So what is the remedy of the prosecution? Well, the prosecution may, number one, amend the complaint or information if the defect can be cured by amendment. Amend the complaint or information if the defect can be cured by amendment. You understand? Like what? Like this one. The complaint or information charges more than one offense. Can that be cured by amendment? Of course, that can be cured by amendment. Or, number two, refile the case. Refile the complaint or information. As when, let us say, the motion to quash was granted on the ground that the court has no jurisdiction over the offense. Then you simply refile it in the court of proper jurisdiction. You understand? Or, the next one is appeal from the order granting motion to quash. Appeal. Now let me tell you something about that one. If the motion to quash is granted on this ground, or on this ground, the only remedy of the prosecution is to appeal. Okay? It cannot refile, it cannot amend. It can only appeal from the order granting motion to quash. If the motion to quash is granted on this ground or on this ground. What is that on this ground? You should memorize what? Yung extinction, yung the double number. Because if you refile, it will again be dismissed on the same ground, di ba? So your only remedy is appeal from the order granting motion to quash. Now, going back, suppose no PI was conducted. And there should be a PI because the penalty is at least 4 years, 2 months, and 1 day. Question. May the accused file a motion to quash on the ground that no preliminary investigation was conducted? That's the class. No, because that is not among the grounds in a motion to quash. Let me tell you something about this one. That a motion to quash is a glance in itself because it can be filed only on any of these grounds. You cannot file a motion to quash on a ground other than this one. You follow? So if they would ask you the very exam, why do you think that a motion to quash is a plan in itself? Then you say that. Because you can file it only on any of the following grounds. Outside of this ground, you cannot file a motion to quash. Alright? Any, that will be number 61. Alright? So pa? Yeah. Provisional dismissal. By the way, motion to quash is in Rule 117. And provisional dismissal is also in Rule 117. Now look at this one back. That a case or a criminal case may be dismissed provisionally only with the express consent of the accused. What kind of consent? Express consent. What about if the consent is implied? No, that's not good enough. Because the rule says it must be with express consent of the accused. And with notice to the offended party. Alright, now look, if a case is dismissed provisionally, the dismissal may become permanent if the case is not revived within 1 year from the date of its dismissal or 2 years. When is it 1 year? If the penalty is what? Is fine of any amount, or imprisonment not exceeding 6 years. If the penalty is imprisonment exceeding 6 years, then the dismissal becomes permanent if the case is not revived within 2 years from the date of its dismissal. So, 1 year in 2 instances. Penalty does not exceed 6 years, penalty is fine of any amount. You follow that? But when the penalty is imprisonment exceeding 6 years, then it is 2 years. Look at this one. By the way, that was asked in the bar exam in the form of an MCQ last year, diba? 2 years, 1 year, ganyan. Question. what's the distinction between motion to quash and provisional dismissal? Well, number one, a motion to quash is a class in itself because it can be filed only on any of the grounds provided for in Rule 117. But a provisional dismissal can be had for any reason at all, even for no reason. You understand? Number two, a motion to quash is filed by the accused. But a motion for provisional dismissal may be filed by the prosecution or by the accused or jointly by the accused and the prosecution. The third one, a motion to quash must be in writing, while a motion for provisional dismissal can be made orally in open court. And then, a motion to quash must be filed at any time before the accused enters the plea as a rule, while a motion for provisional dismissal can be made any time. Alright? So these are the distinctions between provisional dismissal and motion to quash. Now, here was this case that was decided not long ago. Let me tell you something about this case, but first of all, I'd like you to take note that if an information does not contain the approval of the chief of the prosecution office, that information is void. Hello? Have you seen a sample copy of an information plan? So if you have let's say that this is information, and then this is the signature of the fiscal filing information, and then almost at the bottom part, there is the word that says approved, and then signed by the chief of the prosecution office, like the city fiscal or the provincial fiscal. You know what I'm saying, man? In People versus Garfin, it was held that if the information does not contain the approval of the chief of the prosecution office, that information is void. Okay? So, as it happened in that case of People versus Garfin, the information did not contain the approval of the fiscal. It was one. When the accused was arraigned, he pleaded not guilty. And then the case was set for pre-trial and then trial. Alright? And then, People versus Garfin. Arraignment, he pleaded not guilty, and then pre-trial and then trial. While the trial was going on, with the prosecution presenting evidence, the accused filed a motion to quash. The fiscal promptly opposed the motion, arguing that it was too late in the day to file this motion. The time to file the motion to quash, said the fiscal, is before the accused enters the plea. In this case, the accused already entered the plea, pre-trial was already conducted, and in fact, trial is now going on. And so, when the issue went to the Supreme Court, the Supreme Court said that if the information does not bear the approval of the chief of the prosecution office, that information is void. And if the information is void, the court will never acquire jurisdiction over the case. You understand? And then, in the case, the Supreme Court said It is only by means of a valid information or valid complaint that the state can invoke the jurisdiction of the court. So when information is voiced, the court never acquires jurisdiction. And therefore, the ground is fine. Okay? And that can be invoked at any time, even after the accused has already entered acting. Then, free trial? Yeah, free trial. You take note of the purposes of free trial. Can you memorize that? Purposes of free trial in a criminal case. Number one, plea bargaining. Plea bargaining. Then number two, the stipulation of facts. Then number one, marking for identification of evidence. Then number four, waiver of objection to the admissibility of evidence. And then number five, modification of the order of trial if the accused admits the charge but interposes a lawful defense. Then number six, other matters as may aid the court in the prompt disposition of the civil and criminal aspects of the case. If they would ask you that in the bar exam on Sunday, do not start by saying number one, other matters. Number one, other matters. Okay? Can they ask you a question based on this one? Yes, but number one, question. May the court require the accused to present evidence first? Ikaw muna. Ayaw ko. Hindi, ikaw muna. Ikaw ang abogado, ikaw muna. Mag-present ng ebidensya. May the court require, may the court compel the accused to present evidence first? What do you think? Dr. Class? No. Otherwise, you will violate the right of the accused to be presumed innocent. Imagine, he will now be proven his innocence. Right from the start, he now has the burden of proving his innocence. You know what I'm saying, class? So the court cannot compel the accused to present evidence first. Understand? Is there an exception? Yes. Except if the accused admits the charge, but interposes a lawful defense, in which case the order of trial may be modified. That was asked one time in the bar exam. The question was, what is reverse trial? So, are you following class? Are you still with me? No. Or you're now against the Messiah? Ako, nakabali na ako eh. I hope to those of you who have not been to Baguio is a city where if it is not raining, it looks as though it is going to rain. That's Baguio. You walk in the clouds, among the pine trees. So it's kind of romantic sometimes. Imagine walking in the clouds. You don't do that in New York. You don't walk in the clouds. Alright? Look at this one. But don't say in Baguio where I teach, every time a student makes a mistake like that, I go, halika! Ganun yung pulo niya sa wall. But I can do that here. So, ito na yun. Don't say, yes, sir, the order of trial may be modified if the accused admits the offense. If the accused pleads guilty. Hindi ka. You say, if the accused admits the charge. The charge. He's not pleading guilty, you see? No, he's just admitting the charge. Did you kill him? Yes, I killed him. Did he admit? But he interposes a lawful defense. He will say, I killed him in self-defense. Then, in that case, God, because after all, the accused has already admitted the charge, the order of trial may be modified. So the accused may now be required to present his evidence for trial. Okay? By the way, plea of guilty, the accused must be arraigned where? In open court. How? By reading to him the complaint or information. In what language or dialect? In the language or dialect that he understands. Okay? He will be arraigned in the language or dialect that is known to him. Question. What are the two parts of an arraignment? Well, number one is what? The reading of the complaint or information to the accused. The accused must be present, and he must personally enter his plea. So the one, plea. Okay? Reading of the complaint or information, and then the accused enters the plea. Question. Can you arraign the accused in absentia? No, you cannot, because the rule says he must be present at the arraignment, and he must personally enter his plea. He must what? Personally enter his plea. In old days, when I was a young attorney, I became an attorney in 1975. You were still in high school. In those days, I've been in this job for a very long time. 75, how many years ago? More than 30 years ago. And in those days, when you, like we represent, we are representing a prominent member of the community. In the case, we can say the other place, this representation has already informed the accused of the nature of the accusation against him. He understands the information, and he weighs the reading of the information, and through counsel, he enters the plea of not guilty. Pwede ano? Ngayon, pwede pa ba? No more. Because the rule is that the accused must be present, and he must personally enter his plea. So, okay? Well, this one cannot be waived. You cannot waive that. I waive the reading of this permission. No, you can't do that. Alright? That is one right that cannot be waived. If the information or complaint is read to the accused, what are we complying with? We are complying with the right of the accused to be informed of the nature and form of the accusation against him. That right, the accused cannot waive. You follow that? But what about the next one? Please. Well, the accused must personally enter his plea. But let me tell you something about it. So there are instances when the court itself will enter a plea of not guilty for the abuse. When? Number one, when the accused refuses to enter a plea, then the court will enter a plea of not guilty for him. Why should the accused refuse to enter a plea? As when he is contemplating on filing a motion to quash. You understand? Then the accused will say, with due respect to the court, Your Honor, I refuse to enter a plea. Then the court will say, enter a plea of not guilty for the abuse. You know what I'm saying, class? Number two, if the accused enters a conditional plea of guilty. Conditional plea of guilty. By the way, a conditional plea of guilty is void. Does not authorize. As when, ikaw, inaamin mo ba itong demanda sa iyo na panggagahasa? Inaamin ko po. Ngunit, hindi naman po ako nagkumpita. Siya naman po ang nagbayad sa hotel. Ano? Hindi ko na sa class. Siya na po ang nagdala sa akin doon eh. Pinainom po ako. Itong nakainom po ako. Wala na akong magawa. No. That's a conditional plea of guilty. That is not allowed. Now look, if the accused enters a conditional plea of guilty, then the court will enter a plea of not guilty for him. You understand? And then, the third one, if the accused pleads guilty, but present exculpatory evidence. The accused pleads guilty, but present exculpatory evidence. As when charged with homicide, the accused was brought to court. As when arraigned, he pleaded guilty. And then he said, Your Honor, please, I be allowed to present evidence on mitigating circumstance of his complete self-defense. Pwede bang gano'n? Yes. Also, the court allowed him to present evidence on what he called mitigating circumstance of his complete self-defense. So he called some witnesses. But after the witnesses had testified, the court became convinced that what happened was complete self-defense. You know what I'm saying, class? So that was the accused pleaded guilty, but presented exculpatory evidence. Then the court must consider the plea of guilty withdrawal and enter a plea of not guilty for him. So give our readers consequence. The court will enter a plea of not guilty for that. By the way, you know plea bargaining? But with the consent of both the prosecution and of the offended party, the accused may plead guilty to a lesser offense, which is necessarily included in the crime charge. Like the charge against the accused is murder, and then the accused will say, I plead guilty to homicide. Then that is allowed in a plea bargaining. You understand? You don't have to amend the complaint or information. The information or complaint will be read to the accused, and then the accused will say, I plead guilty to homicide. It should be a plea of guilty to a lesser offense. That is what happens in a plea bargaining. You understand that? And so there was the case. Let me show you the case. People of the Philippines were sent for rape of a woman who at that time was only 17 years old. Okay? And when, in a plea bargaining, the offended party must also give her consent or give consent. Except in for what? The offended party is duly notified, but he fails to appear at the arraignment, notwithstanding notice to him, then there can be a plea of guilty to a lesser offense with the consent of the prosecution alone. Although they know that there are certain instances when plea bargaining is not allowed, like violation of Republic Act 9165. Plea bargaining is not allowed. Okay, now look at this one. So X was charged with rape. When he was called for an arraignment, everybody was present, W was there, even the mother was there. And then when the case was called, his counsel said, Your Honor, please, the accused would like to enter into a plea bargaining. That's very nice. What you say is that we're open to proposals for plea bargaining. And then the accused said, Your Honor, please, I will plead guilty. What's the penalty for this offense? The court said, reclusion perpetual. Sounds fine. Okay, perpetual. Sounds fine. But what does that mean, Your Honor? It means you'll be shut out for the rest of your life. Then that he said, Your Honor, if I plead guilty, is it okay if you give me only 10 years? I plead guilty. Give me 10 years. Okay, the court said, just ask. So what do you say is not? That sounds good to me, but then I'll ask the mother of the girl. Okay, that's enough. What about the girl herself? Okay, also. So everybody said, okay. So the accused was arraigned and he pleaded guilty, and then he was given a straight penalty of 10 years. You understand that? And then the accused is now in chains. With the chain, serving his sentence. And then the father of the girl arrived from Dubai, Dubai. And then he learned what happened, and he was not taken. Why? Well, this is supposed to be reclusion perpetual. So he ran to the fiscal's office. He asked the fiscal to refile the case. Also, the fiscal refiled the case. This now the second case involving the same rape of the same woman. And then the accused filed a motion to pass alleging double jeopardy. Question. Is there double jeopardy? The answer is you know why? Because one requisite of double jeopardy is that in the former case, there must be a valid information, a valid plea, and a court of competent jurisdiction. Is there a valid information? Maybe so, but the plea is not a valid plea. Why not? Is that not plea bargaining? No, that's not plea bargaining. Because in a plea bargaining, the accused pleads guilty to a lesser offense. But in this case, he pleaded guilty to the same offense of rape. That is not plea bargaining. You know what I'm saying, man? As he imposed a condition, I plead guilty, but give me 10 years. That's a conditional plea of guilty, which is not having. What the court should have done is what? To disregard that conditional plea of guilty and enter the plea of not guilty for them. So if they would ask you a problem like this one, they just might ask you, when the problem is so easy, it's so easy, don't become very excited. Take it easy. You compose yourself and take it easy. Take it easy. You know what I'm saying, man? May baga ko napakadali. They get very excited. Wala na, nawawala yung diba? So if they would ask this in the Barca, all of a sudden they don't be very excited. Simple lang. Of course, by the way, you were told how to answer this problem. Diba? What else?
Break, Joseph. Break.
Great. Baguio, you don't have break in Baguio.
Yeah.
Break for how many minutes?
5 minutes.
5 minutes or 15 minutes? 5 minutes.
Break. Kita pala ako. Kuya ba? Kuya, gusto mo magpasiro?
Meron na raw.
Meron na kayo dito? Meron na kayo dito? Ito kasi yung walang yung nalilito kayo kahapon. Ano, 15 days rest. Nakibigyan ko.
Nabasa ko.
Hindi ka po.
Oo, nabasa ko na sa isa kong
No, meron ka na.
Thank you. Yung Napes. Thanks. Salamat ba?
Ina, patayin ko na ba, Pin? Oo. Patayin ko ba yung plastic? Meron na mag-record si ano eh. Wow! Wow! Opo, ganun lang. Dalawa kasi ano naman ka nang bigay. Or, di ba? Rider. Ginawa nilang dalawa yun. Ang punta ko naman, Gordon, ay, wala sila. Naka-bracer. Kaya sa barang sawa na sa okay lang commercial. Problema sa ako Okay na naman. Lalo na pagka sinabi ka. Ay, wala.
Ay, si Kapitan.
Let's pursue now.
Red.
Right, anything you'd like to be done in particular? Huh? Okay, so let's talk about gain. Gain is also called bond. Right? So you can say gain, you can say bond, but never say bail bond. If you say bail bond, just like saying mansion house. Like in Baguio, it's a mansion house. Alright? Look at this one, bail. In what form may bail be given? Double round in the Bible not many, many times. In what form may bail be given? Translation, what are the kinds of bail? You should know how to translate a question. Then say number one is cash deposit. Cash deposit. And then property box. Property box. Then you have corporate surety. And then recognizance. Recognizance. Some people pronounce that recognizance. Yan masyado party yun. Recognizance. Mas macho. Dating, diba? So, recognizance. One good thing about the word Islam is that you don't have to speak. You just have to write. Alright, now look at this one, cash deposit, property box, corporate surety, and recognizance. Question is, in what instances may a person be released on recognizance? Then you have the following, number one, in light offenses or where the penalty does not exceed 6 months of imprisonment. Number two, the accused is a youthful offender. Then the third one, the accused has been detained for a period equal to or more than the minimum of the imposable penalty. Equal to or more than the minimum of the imposable penalty without regard to modifying circumstances. And then the fourth one is the accused files an application for probation. Then what? The accused may be released on recognizance. Question. If the accused is charged with homicide, may he be released on recognizance? Well, yes, in the following instances. If he is a youthful offender, or he has been detained for a period equal to or more than the minimum of the possible penalty. You know, class, you have the minimum, you have the medium, and the maximum. Like if it is reclusion temporal, the minimum is from 12 years and 1 day to 40 years, 2 months. So if the accused has been detained for more than 15 years, my goodness, just is delayed, then he can be released on recognizance. What happens if the accused has been detained for a period equal to or more than the maximum of the possible penalty? Then the accused must be released from confinement immediately. You understand? If, let's say, the charge is homicide, he has been in jail for 21 years, he must be released immediately. Without waiting, without recognizance. Right? Look at this one. Now, have you heard about that case of People versus Colinares? Okay? Arnel Colinares. This one is in what happened in that place. Sometimes I write the word because I cannot pronounce it. I have a problem with my speech. Have you noticed it? I was born with a speech defect, and the irony is I make a living by talking. I just have to accept my defect, you know. Nobody has rapid thought that life should be fair. But you just have to live with what you have. Accept who you are and live with it. But instead of me crying over it, I might as well do something about it. So I can't say that one without embarrassing myself. I will say, how will I say that? Papa. Tama din. Wala, pwede. Project tama din. Tama. Wala, talaga. Very difficult for me to say that. But in the case of Arnel, okay. Arnel Colinares. That's the name. The rule is that probation and appeal are mutually exclusive. You know what that means? If you appeal, you cannot file an application for probation. And if you file an application for probation, you cannot appeal. That's why it has been said that probation and appeal are mutually exclusive. One excludes the other. You can't do them both. Follow that? And so if, let's say, you appeal, and then your appeal is dismissed, for example, then you cannot file an application for probation anymore. Follow? Even if, let's say, like you were charged with a crime, and then you appeal, and then on appeal, the court lowered the penalty to less than 6 years, and so you don't think you can appeal. You file an application for probation, that application cannot be granted because if you appeal, you cannot file an application for probation. That is the rule until the case of People versus Colinares. What happened in that case was that Colinares was charged with frustrated homicide. All along, he was insisting that the crime he committed is only attempted homicide because the injury was not fatal enough to have caused the death of the victim. That was his insistence right from the beginning. But he was found guilty of frustrated homicide. He went to the Court of Appeal, still insisting that if at all he should be held guilty, he should be held guilty only of attempted homicide. But the Court of Appeal did not listen to him. The Court of Appeal sustained the judgment of conviction. And so he went to the Supreme Court. And here he still insisted that the crime he committed is only attempted homicide. Besides, the Supreme Court said, of course, the crime is only attempted homicide. And so, the Supreme Court imposed upon him a maximum of 2 years and 4 months of imprisonment. Whereas in the court below, the maximum was 6 years and 1 day, and that disqualified him from filing an application for probation. And so this time, the Supreme Court directed both parties, the soldier and the accused, to submit simultaneously a memorandum on whether or not our dead can be allowed to go on probation. So they submitted their respective memoranda, and when the Supreme Court decided this case, the Supreme Court said it was a divided Supreme Court. Divided. It's 8-7 split decision. You know what I'm saying, class? And the Supreme Court said our dead should be allowed to file an application for probation. And so he was directed to file this application within 10 days from receipt of a copy of the decision. The Supreme Court said, of course, Arnell insisted right from the beginning that the crime he committed is only attempted homicide. And so, if that was the ruling then, he could have filed an application for probation even at that time. So look at the one that here it was held that Arnell should be allowed to file an application for probation. Follow? That's 2011. Alright, now, you know that faith is what? Sometimes a matter of right, sometimes a matter of discretion, and sometimes neither a matter of right nor a matter of discretion. They ask that in the bar exam many, many times. Have you noticed that? They ask that in the bar exam many times. So let's look at it one more time. Okay, so instances when bail is a matter of crime. You should know these instances. Number one, before or after a judgment of conviction by the FCC. So before or after a judgment of conviction by the FCC. And then number two, before a judgment of conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment. Although everybody here knows that the imposition of death penalty is prohibited. Diba? Republic Act 9346. So, look at this one. Before a judgment of conviction by the RTC of an offense not punishable by death, not punishable by reclusion perpetua, not punishable by life imprisonment. The third one, before a judgment of conviction by the RTC of an offense punishable by death, reclusion perpetua, or life imprisonment, and the evidence of guilt against the accused is not strong. Then bail is a matter of right. Okay? Matter of discretion when, after a judgment of conviction by the RTC, and the penalty imposed by the court is what? Is less than reclusion perpetua or life imprisonment. After a judgment of conviction by the RTC, and the penalty imposed is less than death, less than reclusion perpetua, less than life imprisonment. It's a matter of discretion. Neither a matter of right nor a matter of discretion. Before a judgment of conviction by the RTC of an offense punishable by death, reclusion perpetua, or life imprisonment, and the evidence of guilt against the accused is strong. Before a judgment of conviction by the RTC of an offense punishable by death, reclusion perpetua, or life imprisonment, and the evidence of guilt against the accused is strong. Then number two, after a judgment of conviction by the RTC, and the penalty imposed is death, reclusion perpetua, or life imprisonment. In number two, do not anymore say, and the evidence of guilt is strong. To say that after a judgment of conviction, and the court has imposed as penalty upon the accused, then reclusion perpetua or life. And then the third one, after a judgment of conviction by the RTC, and the penalty imposed against the accused is one, imprisonment of more than 6 years, but less than death, reclusion perpetua, or life imprisonment. And the accused is a recidivist a wayside recidivist, a habitual delinquent, or that he committed the offense with the probating circumstance of resurrection. Yung mga iba, they say, resurrection. Sabi mga nila. Okay? B, the accused escaped from legal confinement, evaded service of sentence, or violated the condition of his parole. And then C, that the accused committed the crime while on probation, parole, or conditional pardon. D, that the accused, that the probability of flight is strong. Probability of flight is strong. And then E, that there is a likelihood that the accused will again commit a crime if during the pendency of the appeal. Okay, so you have A, B, C, D, E. And then number 4, after the finality of adjustment of conviction, unless the accused files an application for probation. Okay? Let me explain that to you. So number 4 is after the finality of adjustment of conviction. Except if the accused files an application for probation. What happens to the judgment if the accused files an application for probation? The judgment becomes final. So, understand? Yeah, look at this one. So here, before or after a judgment of conviction by the FTC. But if the judgment of conviction becomes final, then you belong to this situation already. You understand what I'm saying, class? You don't understand? You don't understand? Okay. Okay, now look. If you look at this one, is there anything that attracts your attention? You look at the one, this question. By the way, who's this question? The court, not the accused. The one is a very lucky guy. Right? If you look at this one, class, and then you look at this one, then you will notice that this and this one almost identical. You are? No? Oh, look at that. Less than that. Look at this one. If what you have is this one alone, that's what you have, then bail is a matter of discretion. Suppose the court denies bail, then does the court discretion? But may the court allow bail? Yes, also. But look at this one. But if you have this one plus anyone of these, anyone, then the time bail is neither a matter of right nor a matter of discretion. If the accused will file bail, the court must deny the application. If it is this one plus anyone of these circumstances. You follow? Now look. Suppose you have only this. May the court deny bail? Yes. May the court allow bail? Yes. Suppose you have this plus anyone of this. May the court deny bail? The answer is of course. The court must deny bail. May the court allow bail? No. The court cannot do that. And so, What do you call A, B, C, D, and E? You call them A, negating circumstances. What do you call them? You call them A, negating circumstances. So if in the bar exam, they will ask you, what are the Dale negating circumstances? Then don't say, the following are the justifying circumstances. They're gonna, the following are the aggravating. No, that's not the one. Dale negating circumstances. The presence of anyone negates the right to be. You understand? So it's called Dale negating. It's negate. No? Are you still with me?
Yes.
The abuse is a recidivist, a wayside recidivist, a habitual delinquent, or that he committed to offense with the aggravating circumstance of what? Reiteration. Reiteration. It's not macho. Reiteration. Basta. The accused has escaped from legal confinement or evaded service of his sentence or violated the conditions of his faith. Yung proof, ang pagkasabi doon ito, violated the conditions of his faith without justification. My goodness, if you violate, that should be without justification, di ba? So, you end there. Would you still be correct? Of course. Then, you mentioned all of them. Okay. Question. Is there bail in deportation proceeding? Deportation? Yes, but the one who can grant bail is the Commissioner of Immigration. Not important. And that is discretionary. Right? But the Commissioner may grant bail only in serious deportation proceeding. But the moment there is now a deportation order, he cannot grant bail anymore. Question. Is there bail in extradition? Yes? Okay. But the extradite, that's how you call him, extradite, D-E-E, must prove by clear and convincing evidence that is not what? A blind reason. But I can't understand that, do you? You understand that? I can't understand. I cannot understand. I don't know about you if you can understand. By the way, in the hierarchy of evidence, what do we have at the top? We have what? Proof beyond reasonable doubt. Then you have preponderance of evidence. And then substantial evidence. But look at this one. Between proof beyond reasonable doubt and preponderance of evidence, there is something there in between. And that is clear and convincing evidence. And you need clear and convincing evidence in some instances. Number one, in application for bail in extradition proceedings. You need not only substantial evidence, but clear and convincing evidence. That is more than preponderance of evidence, but less than proof beyond reasonable doubt. You follow that? If you claim self-defense, you need clear and convincing evidence to prove your claim of self-defense. If you claim instigation, you need clear and convincing evidence to prove your claim of instigation, etc. To overcome unauthorized document, you need clear and convincing evidence at all. Number extradition. The extradite files an application for bail. Then he must present clear and convincing evidence to prove that he is not a flight risk. Did I say I cannot understand that? That's what I said. You know why? Yung extradite kasi, nag-escape sa ibang country, di ba? He escaped. He's now in the Philippines. Nasa America. Nag-escape sa Germany. Germany to Amsterdam. Amsterdam to the Philippines. Then, in the Philippines, he will file an application for bail. He will have to prove that he is not a flight risk. Then he will prove he's not a flight risk. Are you kidding? About if I say that in the first time, are you kidding? You understand what I'm saying, class? You understand? No? You have to prove you're not a flight risk because nagaling mo lang nag-escape. Oh. Kaya nga lang dito ka di ba? I don't know if you can follow that. But anyway, that is something they would not ask in the Pakistan. Why can't you do it? Walang ganon. Alright, what else would you want to ask? Anything else? By the way, in the Pakistan, many times in the Pakistan, they ask the question of when is bail a matter of right, when is it a matter of discretion, but they have never asked this one. Because they're very long. That's probably the reason. They might ask you to sign. Something about in past Pakistan, the questions asked were the following. Now, the question is, when is it neither a matter of right nor a matter of discretion? Then this one. You mention all of them. Don't forget the day, the giving circumstance. Sabi, dinidiscuss din natin yung kailangan more political law than remedial law yung whole departure order. Yan, diba? First court can issue a whole departure order, the RTC. Okay. Yan ay based sa circular issued by the Supreme Court that only the RTC can issue a whole departure order. And then came DOJ circular number 41. You heard about it? Issued at the time when the Secretary of Justice has a very unusual name. Ang name niya doon ay the first 4 letters of my name. Do you know my name?
Agra. Secretary Agra.
This is my name, from A to Z. Can you believe this name? That's why I never ran for any political office because of my long name. Even my children might not vote for me. Dapat pa yan. Ako, ano binuboto kasi yung Go. Go. Kaya Sport. Naglutin pa. When I was a pupil, way back in the old days, I already felt injustice. Kasi may kaupo ko doon. And then he would talk to me. And then all of us would be punished. Go to the Lord. Write your name 20 times. Kapala niya, low. Low. Number 1 para ako. Tapos na siya, ako. People smiling. Para sa akin, write your name 1, write your name 29. Yung tama, di ba? Ayun. The name of that official is 1. He issued DOJ number 41. What's that DOJ number 41? Watch, lead, order. Go. Okay? And then there was a change of government, as all of you know. And then there was this former president who wanted to leave the country. And she was not allowed to leave the country on the strength of this DOJ number 41, which was issued during her time. You know what I'm saying? And then the present government was using it against her to prevent her from leaving the country. And then there was a case filed with the Supreme Court. You understand what I'm saying? And then the Supreme Court issued at their own and declared DOJ number 41 void. And then she was allowed to leave the country. And then that was the time when you saw on TV a lady on a wheelchair. And the rest, as some people say, is fun. Tragedy. Then, another time, we again saw somebody on a wheelchair. And then, there was impeachment something. And then another time, there was again somebody on a wheelchair. And he was supposed to be the champion of a boxing match. On a wheelchair. And then today, they're again talking about a wheelchair. Diba? And there will be no end to it. Wheelchair. So in the Pakistan, what is a wheelchair? That's one. I'm not, it's not a joke, I'm just stating something. Kasi somebody gave a joke about wheelchair at ang daming reaction, negative reaction. Dami. Sabi na, hindi daw maganda yung sabi kanya, sabi ng kanya, gano'n. You should be more charitable. Yeah. I don't know. Namisyo ko yung wheelchair kasi, kuha. Alright? So that's me. What else would you want to? We were talking about free trial a while ago. Free trial in a criminal case. Then sometimes you go to section 2 and you will learn that all agreements and decisions made at the free trial cannot be used against the accused unless reduced into writing and signed by the accused and counsel. You know that when you make an admission in the course of a judicial proceeding, that admission can be used against you. The admission is admissible against the admitter. You know what I'm saying, class? But if made as the free trial in a criminal case, that admission or agreement is not admissible against the accused unless it is reduced into writing, signed by the accused and counsel. Then it can now be used against the accused. Question: whose responsibility is it to see to it that the admission or agreement is reduced into writing? Is that the responsibility of the court? The answer, class, no, but it's not the responsibility of the accused. of the court. Is that the responsibility of the accused with more reason? That is not his responsibility. So whose responsibility? The answer, class, that is the responsibility of the prosecution. So they can give that in an MCQ, diba? All agreement or admission as the pre-trial cannot be used against the accused unless reduced in the writing and signed by the accused and counsel. Whose responsibility is this? To see to it that these are reduced in the writing. Is it the responsibility of A, the court, B, the accused, C, the offended party, D, the prosecution? The answer, class, this time is D, the prosecution. Yung MCQ kasi, you try the MCQ, di ba? It's not very easy. So this MCQ, you can have a second best answer. You cannot have a second best. Kailangan yung what you select should be the correct answer. Kaya, that's MCQ. Alright? What else? Judgment. Or the murder to evidence. They give that all the time. We will now talk about the murder to evidence. Yung mga iba, they say, the viewer, kailangan mali yun. Talagang mali yun. Because your word is the word. The word is what? The word. So you say, the murder. Even if you check it. Kaya, the viewer. Wrong. Otherwise, your word is the viewer, which is not correct. Diba? So, in the bar exam, you say, the murder. But they won't ask you that in the bar exam. How do you say, well, no. But anyway, when you become lawyers, this is what you will say in court. When you will become lawyers. So, look at that, this one, look. So, prosecution has presented its evidence. It rested its case. Okay? Then, if you look at the rule, you will find that the court may dismiss the action. The court may dismiss the criminal action on insufficiency of evidence. One, upon its own initiative, but after giving the prosecution an opportunity to be heard, or so, upon the murder to evidence filed by the accused with or without leave of court. Question in the bar exam. May the court dismiss the criminal case on insufficiency of evidence after the prosecution has completed the presentation of this evidence, even without the accused filing as the murder? The accused is not filing anything. But can the court dismiss it on its own initiative? The answer, class, yes, but it must give the prosecution an opportunity to be heard. Did you, nakita ba niyo ito? Have you found it? Let me rewind. Go to 119, section 23. Are you there? Okay, then this is what it says. Section 23, the murder to evidence. After the prosecution raised its case, the court may dismiss the action on the ground of insufficiency of evidence. Then you see number one, diba? Number one, on its own initiative, after giving the prosecution the opportunity to be heard. Or two, did you see number two? Upon the murder to evidence, filed by the accused with or without leave of court. So meaning, the court can dismiss the criminal action of its own initiative, even without the accused filing as the murder to evidence. Did you understand that? Okay. That's why, one, two. But look at this one. Or upon the murder to evidence, filed by the accused with or without leave of court. Now look, where it comes. Suppose the accused files as the murder to evidence, and that the murder to evidence was denied by the court. May the accused still present evidence? The answer is it depends. If the accused files the murder with legal court, and the murder is denied, then he may present his evidence. I'd like you to take note and to remember all the time that an accused who files as the murder to evidence with legal court does not waive his right to present evidence in the event the murder is denied by the court. But if he files as the murder without legal court, then he loses his right to present evidence. In fact, he is submitting the case for decision by the court on the basis of the evidence presented by the prosecution alone. Alright? Well done. In what instances may be said that the accused is filing as the murder without leave of court? Well, if he files a motion for leave to file the murder, that is the motion. Motion for leave to file the murder to evidence. If granted, and then he files as the murder, then he is filing it with legal court. You understand? But suppose it was denied. May the accused still file as the murder, notwithstanding denial of his motion for leave? The answer was yes, in which case he is filing it without legal court. Or he files as the murder without even filing a motion for leave. Then in these two instances, the accused is filing his murder without leave of court. Okay, now, what happens if the murder is granted? Then the case is dismissed. Is that an adjudication of the case on its merit? Yes, because it is made upon consideration of the evidence. Okay? That is the fact of the fact. Question. May the prosecution appeal from an order granting demurrer? Can you understand that question, ma'am? The accused filed as demurrer, and then it was granted by the court, and then the prosecution believes that it was wrong for the court to grant it. Can the prosecution appeal from the order granting demurrer? The answer, class, no, because an appeal from that order will violate the rights of the accused against double jeopardy. So, you follow? It will violate. There is what you call the finality of acquittal rule. Finality of acquittal rule. The moment a judgment is rendered acquitting the accused, that is final immediately. And therefore, you cannot appeal from a judgment of acquittal. You understand? So an order granting demurrer is in fact an acquittal. And therefore, the prosecution cannot appeal because that will violate the right of the accused against double jeopardy. Next question. If appeal is not a remedy, is there a remedy at all? The answer, class, yes. And that is a petition for certiorari under Rule 65. Very difficult to say that. Petition for what? Certiorari. I always have a problem when it comes to words like that. But anyway, that's the remedy. It is condition number one, that the state is denied due process. Who was denied due process? The state. Due process is not only for the accused, it is also for the state. So if the state can show that it was denied due process, then it can file a petition for certiorari to set aside the judgment. The issue in a petition for certiorari is not the correctness of the judgment. It is the validity of the judgment. That is the issue. Is the judgment valid or void? That's the issue. So if void, it will be set aside. Okay? So if the state can show that it was denied due process, it can file the petition. Or number two, that in granting the demurrer, the court acted with grave abuse of discretion, amounting to lack or exchange of jurisdiction, and there is no appeal or anything is treated as adequate remedy in the ordinary course of law. Yeah? You understand? Now look, like in the case of Galvan versus Sandigan Bayan, have you heard about this case? Even before the trial could begin, they already knew that it was going to be an acquittal. Also, the trial was a mock trial. You understand? It was to use the word of one author. It was nothing but fun. A play, a joke, sabi ko, a charade, sabi ko na, It was just what? A play. The judgment of acquittal was a predetermined judgment. Even before the trial could begin, they already knew it was going to be acquittal. That's why the state was denied due process. That's why the judgment of acquittal in that case was set aside. And they were retried. And they're now in jail. Diba? Or, the second one, it can be shown that the court acted with grave abuse of discretion in granting the demurrer to evidence. And you just have to know the distinctions between a demurrer to evidence in criminal cases and demurrer to evidence in civil cases. You memorize the distinction. There's a red book that mentions all the distinctions in a very beautiful way. And the author of that book is a person whose family name or whose name is the same as my name. Okay? Have you seen that book? Very beautiful. Right? Whatever. Discharge of an accused to be utilized as a state witness. Have you heard about Republic Act 6981? What is this? Suppose they will ask you, what is Republic Act 6981? Then you are in big trouble. Imagine they will ask you things like those. But Republic Act 6981 is one, the Witness Protection Program. So, now look at this one. Discharge of an accused to be utilized as a state witness. And this one is in Rule 119. Okay, so 119. Rule 119. Let me show you the requisites so that you can follow. So the first one is there should be more than one accused. That's of course very understandable. So there must be more than one accused. And then number two, before the prosecution grants, it files a motion for the discharge of one or some of the accused to be utilized as a state witness. So the prosecution will file a motion. And it must be with the consent of the accused whose discharge is being requested. He must give his consent. Alright? And then there must be a hearing on the motion. Hearing. And at the hearing, the prosecution must present evidence, and it must also present the sworn statement of the witness whose discharge is being requested. So, the meaning that the accused whose discharge is being requested must execute a sworn statement. Narrating his complicity in the commission of the crime. You understand? Alright? And then, after the hearing, the court is satisfied. Court is not satisfied that, hey, there is absolute necessity for the testimony of the accused whose discharge is being requested. B, that there is no other direct evidence available for the proper prosecution of the offense other than the testimony of the said accused. And then C, that the testimony of the said accused can be substantially corroborated on its material point. D, that the accused whose discharge is requested does not appear to be the most guilty. And then A, that he has not been convicted of a crime involving moral turpitude. Look at this one back. So, if after hearing, the court is satisfied that all of these are complied with, then it will issue an order discharging the accused. It will issue an order discharging the accused. Question: what is the effect of this order? The answer, class, it shall operate as an amnesic. So it operates as an amnesic. Question: this is the sworn statement of the accused whose discharge is requested. Is the sworn statement admissible in evidence? Is that admissible in evidence? The answer is not. If the motion, this is one, motion. If the motion for the discharge of the accused is denied, the sworn statement is not admissible in evidence. But if granted, that is admissible in evidence. And of course, I'm sure you understand the logic, right? Otherwise, they will ask you to make a sworn statement, and then the motion is denied, and then they will use the sworn statement against you. Who's going to make a sworn statement? Right? That's why they know that if the question is that sworn statement admissible in evidence, then you say, if the motion is denied, no, it is not admissible in evidence. Alright? Because the sworn statement will narrate the participation of the accused, di ba? Kasi kung ang sabi niya, sinumpa sa laysay ni Abel. Sabi mo nilo. Tanong, ano ang masasabi mo sa krimen na ito? Sagot, wala akong masasabi dyan. Do you think he will be discharged? His testimony is not necessary. Wala akong masasabi dyan. Sabi ko naman. So he will have to say, ako po ang naghawak sa kamay ng biktima, ako sinastak po nung kasama ko, ako sinastak po din. Wala, malit lang sinastak po, ganyan lang. Oh. Then, question, is that admissible? Depends. If the motion is denied, it is not admissible in evidence. Is that the same as the witness protection program? No, because look at this one. The DOJ can simply discharge an accused without going through all these procedures, even without filing a motion. That is pursuant to the witness protection program. We've been told about the distinction between discharge of an accused and placing an accused or placing a person under the witness protection program. Let's look at the distinction. Number one, you can simply say WPP, or you say Republic Act 6981. But in the exam, don't simply say WPP. You say Witness Protection Program. Republic Act 6981 applies only if the offense is a grave felony or its equivalent under the special law. Kailangan grave. O kaya, yung equivalent sa special law. Like what? Cattle rustling, diba? Hijacking, ano? Huh? You know what I'm saying, class? What crime do you commit if you steal a Carabao? Answer, cattle transit. What crime do you commit if you kill a Carabao? Answer, cattle transit. What crime do you commit if, let us say, you take a Carabao and the owner resists the taking, and then you shoot the owner to death? You kill him. What crime do you commit? Steal cattle transit. What about the homicide? Son, aggravating circumstance. So in the final count of things, the Carabao occupies a higher level than the human being. So next time you see a cow or a Carabao, show some respect. Alright? Ang ganyan ang buhay. While this one, the charge of an abuse to be utilized as our statement applies to any crime. Okay? Number 2. There must be a threat of death or bodily harm to the witness or to a member of his family within the second degree of consanguinity or affinity. But in Rule 119, there is no such requirement. The third one, witness protection program is not available to a member of a law enforcement agency. But there is no such limitation under 119. Okay? Can you see the distinction plan? And then, the next one, fourth one, the exemption or immunity under the witness protection program is granted by the DOJ. But the exemption or immunity under 119 is granted by the court. And then, Republic Act 6981 WTB, the witness may be one of the accused, or he needs not be an accused himself. You understand? Just like in the case involving your good friend Jessica. You know what I'm talking about? She was not one of the accused, and yet she testified as a state witness under the witness protection program. But in 119, the witness who testifies is one of the accused. Hello? He must be an accused. He must be included first in the information or complaint and then discharged. But there is no such requirement under the WTB. And then, the next one is what? That under the witness protection program, the witness enjoys some benefits like housing, allowances, expenses, change of identity, but there are no such benefits under Rule 119. You know what I'm saying, class? They can give you a safe house, lodging, housing, change of identity. In the state, the change of identity could include change of faith. You'll be given a new faith, a new identity. You know what I'm saying? They can give you a set of documents like birth certificate, ganyan. Iba ng pangalan mo. Ang pangalan mo nun ay Juan. That's your name before. Then you were given a new identity. Your name became John Taylor. John Taylor. And you are not playing, you know Elizabeth?
No.
My, he became John Taylor. Alright? But do you know that we have so many immunity? Have you been told about that? Like transfunctional immunity? Have you heard about that? You look at Republic Act 9165. It provides for transfunctional immunity. And what's the other one? Use and derivative use immunity. Use and like, for example, you were able to provide information that led to the arrest of some drug traffickers, something like that, and then you will testify. You might, the DOJ might grant you transactional immunity. And what is that transactional immunity? That the person who testifies cannot be prosecuted for any offense arising from or that might arise from the transaction or event to which his testimony relates. It's also called blanket immunity. You know what I'm saying? Look at this one. This is the transaction or event. This one is the transaction or event. And then you testify regarding this transaction. And then you might have some participation in this transaction. Then when we say transactional immunity, it means that you cannot be prosecuted for any offense arising from this event or transaction. You understand? Like, let's say that you also participated in the production or shipment of some bags of shabu or marijuana, okay? Then you cannot be prosecuted. You cannot be prosecuted for any offense arising from this transaction to which your testimony relates. On the other hand, that's why it's called blanket immunity, total immunity. On the other hand, use and derivative use immunity is simply that your testimony cannot be used against you in any future prosecution. You can still be prosecuted, but your testimony cannot be used against you. Okay? So, you look at Code 119 in relation to what? Republic Act 6981, and then also you must know how to explain transfunctional immunity and use and derivative use immunity. Then judgment. Suppose they would ask you one question in remedial law. Pagdating mo sa law, they would give you the set of questions. Yes, there's something that says there's only one question in remedial law. Answer this and go home. So look at that. The question is, may the judgment be promulgated by the clerk of court? What do you say? May the judgment be promulgated by the clerk of court. You know clerk of court? Clerk. Then you go to Rule 120 section 6. It says, when the judge is absent or outside the province or city, then the judgment may be promulgated by the clerk of court. Let me read that to you. Okay, go to section 6. Of Rule 120, are you there? Then you go to the last part of the first paragraph. Let me read it to you. It says, when the judge is absent or outside the province or city, comma, the judgment may be promulgated by the clerk of court. A while ago, Hong you said no. You're in big trouble. Alright, let me explain that to you. When the judge is absent or outside the province or city. By the way, class, my grammar teacher tells me, don't say outside of. You don't say outside of the house. He is outside of the house, bro. You say outside the house. Look at that one. You say outside the province or city. Then make a note, correct English. Alright? Question. Suppose the judge is absent because he was a week before the schedule, a week before the date of the promulgation, he died. That's why he was absent. Or he was promoted to the court of appeal. Or he has his certificate of candidacy and is now being resigned. Question. May the judgment be promulgated by the clerk of court? The answer is no. When we say judge is absent, meaning temporary absent. Meaning, he is still the judge of the court. In fact, look, if at the time of the promulgation, the judge who signed the decision is no longer the judge because he died, or he resigned, or he got promoted to another position, then the promulgation is void. Meaning, therefore, that the promulgation of judgment must take place, must happen, while the judge who signed the judgment is still incumbent judge. You understand? That's why the word absent in section 6 simply means temporary absence. So if the judgment is promulgated, when the judge who signed the judgment is no longer the judge, the promulgation is void. By the way, you simply say void. You don't say null and void. If you say null and void, that is the same as Ilman. Same as mansion house. Same as seat and receipt. Same as over and above. Kaya, yung mga abogado kasi, mga judges, ang hilig sa mga double, complex, over and above the objection of counsel. Maganda. If you know your honor is null and void, maganda. You seem to say void. Yung mga dito siya naman, hereby, said, convey, and transfer. Maganda. Dami na sabi. That's why there was this old man who said, it was a good thing the Genesis was not written by a lawyer. So, you know the Genesis? It begins with this phrase. So, in the beginning, God created the heavens and the earth. very powerful. You tell a lawyer to write something like that. He might come up with a statement like, in or about the beginning. God created, built, established, and put up. So it was a good thing. The Genesis was not written by our own. Well, it's 12 o'clock in my watch. Are you coming back to South? Because if you are, we will talk about the rest of the questions that will be asked.
Okay.
What time are you coming back?
1:30.
And then we will talk about appeal. That's very interesting. They will give appeal in the very time. Okay? So, we come back at 1:30. once again. Let us say that on Sunday, they would ask you a question like, may a judgment be promulgated notwithstanding the absence of the accused? A while ago we said that there can be no arraignment if the accused is not in court. Alright? So it is important that the accused should be in court so that there can be an arraignment. But suppose the accused is notified of the date of the promulgation of the judgment, but on that day the accused fails to appear notwithstanding due notice to him. The question is, may the judgment be promulgated anyway, notwithstanding the absence? The answer, class, is yes. So there has been trial in absentia, and the judgment can be promulgated also in absentia. That's why somebody said, try me in absentia, judge me in absentia, and shoot me in absentia. Something else. Alright? But kidding aside, there can be a promulgation even in the absence of the accused, provided there is due notice to him. Alright? So that is important, that it must be shown that there was notice to him. And so the next question is, how will the judgment be promulgated in the absence of the accused? The answer, class, by recording the judgment in the criminal docket and furnishing the accused with a copy of the judgment as his last known address or through his counsel. So two things you must do. The judgment must be recorded in the criminal docket. Alright? And the accused must be furnished with a copy of the judgment from his counsel or at his last known address. Question. Let us say that the accused was present, but his counsel was absent, notwithstanding notice to his counsel. And the judgment was promulgated in the absence of the counsel for the accused. The question is the promulgation valid? The answer, class, yes. There is nothing in the rules of court requiring the presence of counsel at the promulgation. So if the judgment can be promulgated in the absence of the accused, then it can also be promulgated even in the absence of counsel for the accused. So they might just decide on Sunday to give you a true or false question. Alright? That's not difficult to imagine. They could give you a question like that. And then the question is, a judgment can be promulgated even in the absence of the accused. Then the answer is true. Alright? Do you have any problem with that? Okay. And, well, you know that if the judgment is one of guilty, it's a judgment of conviction, then the accused may appeal from that judgment within 15 days from promulgation. So that's 15 days. Alright? But let us say that the judgment was promulgated on July 1. 15 days from July 1 is July 16. Do you know that? Okay. You count 15 days from July 1, then you arrive at July 16. Okay? Now, so here if the judgment is promulgated on July 1, the accused has until July 16 to appeal from the judgment. You follow? That's 15 days. Why is it that July 15 days from July 1 is July 16? I told you you have 15 days. Something happened on July 16, 1990, you know that? There was an earthquake that hit Baguio City, and that was the most intelligent earthquake there ever was, because it knew the alphabet. The places that were hit were A, Agoo, B, Baguio, C, Cabanatuan, D, Taguma, E, Itihan. So, it knew the alphabet. Next time it would be S, Fogao. And on July 16, 1945, do you know what happened? July 16, 1945. Do you know the Manhattan Project? The Manhattan Project is the project, the code name of the project that developed the atomic bomb. It's called Manhattan Project. So if you remember J. Oppenheimer, one of the scientists. And then they developed the atomic bomb. Alright? And just to find out if they were successful, they exploded the atomic bomb by way of testing it. On July 16, 1945. So that was July 16, 1945. In Alamo Gordo, New Mexico. And then a few days later, on August 6, 1945, they dropped one of these bombs in Hiroshima. You know the Enola Gay? That's the name of the plane that dropped the atomic bomb in Hiroshima. And then 3 days later, they dropped another one in Nagasaki. And the rest, some people say, is not history. And then July 16, 1949, somebody was born. And he's now 63 years old, going 64. Alright? We wrote a book, read one, and somebody tells me that that's the best book in remedial law. Somebody tells me. I'm not sure though what to say. And then, 20 years later, July 16, 1969, that was the launching of Apollo 11 that brought Neil Armstrong to the moon. And he said, one small step for man, a giant leap for mankind. So you count 15 days from July 1, that's July 16. Alright? You have any problem with that now? Okay. Hang on. But what about if they would ask you a problem like this one? In June, the accused was given a notice. Notice of promulgation of judgment. And the notice is stated that the promulgation was to be held at 8:30 in the morning of July 1. Notwithstanding notice, the accused did not appear on July 1. And so the judgment was promulgated by recording it in the criminal docket and furnishing the accused with a copy thereof as his last note of grace or to his counsel. 2 days later, or on July 3, the accused learned about the judgment, finding him guilty of homicide. And he would like to appeal from the judgment. You know what I'm saying, class? And then the question is, in the exam, until when may the accused appeal from the judgment? Do you know the answer? Do you understand the problem? Don't understand? The accused was notified of the promulgation. He did not appear, notwithstanding notice to him. And so the judgment was promulgated on July 1. And then he received a copy of the judgment on July 3. It was then that he learned that he was convicted. Also, he would like to appeal from the judgment. Question: until when can he appeal? The answer, class: he cannot appeal. He cannot appeal. And so the question is misleading. Because the question is, until when can he appeal? And the answer is, the accused cannot appeal. You know why? If the accused is notified of the promulgation of judgment, but notwithstanding the notice to him, he fails to appear, then the accused, the judgment may be promulgated just the same, but the accused will lose all remedies against the judgment. He will lose them. What are the remedies against the judgment? Against the judgment of conviction, one is appeal. Number 2 is motion for new trial. Then you have also motion for reconsideration. And then you might want to include motion for reopening of trial. Okay? But if the accused fails to appear at the promulgation, notwithstanding notice to him, then the accused will lose all the remedies. He will lose all remedies available against the judgment. You understand that? So if that would be asked in the bar exam, may the accused appeal from the judgment? Then the answer is no. He cannot appeal. Why not? Because he has lost the remedy of appeal. Alright? Is that clear enough? Question: sir, if the accused has lost these remedies against the judgment, is that the final thing for him? Is there still anything he can do? Well, yes. Within 15 days from promulgation, counted from July 1, the example we have, within 15 days from July 1, the accused must surrender himself to the court and file a motion for leave to avail of the remedy. What is the name of this motion? It's called motion for leave to avail of the remedy. He must do these 2 things within 15 days from promulgation. What are the 2 things he must do? Number 1, he must surrender himself to the court. And then he must file a motion for leave to avail of the remedy. In his motion, he must explain why he failed to appear at the promulgation. And if the court finds the reason to be meritorious, the court may grant his motion. And then he can now avail himself of the remedy within 15 days from notice of the order granting this motion. You understand that? So look, in the example given, let's say that within 15 days from July 1, he surrendered himself, and then filed a motion, and then the court granted his motion, and then he received a copy of the order granting his motion on August 1. That's when he received a copy of the order granting his motion. Then he will have 15 days from July 1 to appeal from the judgment or to file any one of the motions. You understand that? In a way of speaking, he was able to extend his time to avail of this remedy. Okay? Understood? So, he will file a motion. What's the name of his motion again? Motion for leave to avail of the remedy. What will he state in his motion? He will have to explain why he failed to appear at the promulgation. Like, suppose they would ask you, give an example of a good reason. Sige nga, nagkasakit, that's one. He was brought to the ICU, of course, he got attend the promulgation. Second one, pinaglaban ng misis. Pinaglaban. Kaya he was not able to sumakit ang katawan, he was not able to don't mention the second one. There was a soldier. Here was a soldier, an old one. And then he said, when he was speaking before the Joint Congress of the United States, he said, old soldiers never die. Take away. You know who said that? No? That's number 25 in the Baritan. So, the same one, the same soldier who said, I shall return. But he was the one who said, all soldiers never die. They just fade away. But there was this old man who said, all lawyers never die. They just lose their appeal. So we now take up appeal or appeal. Introduction. What's that again? All lawyers never die. They just lose their appeal. Right? So let's talk about appeal. By the way, you say appeal from a judgment. That's your preposition. You appeal from a judgment. Okay? You appeal to a higher court. Tomorrow, we will have a lecture also at the... I forgot the name of the place. And I was asked to give a lecture not on remedial law, but on legal writing and English. Sabi ko bracket?
Sama kami, hindi rin.
Yeah, something? So we got about it in the evening. Like 5 o'clock? No, 5:30. No.
5:50.
So, you want to go out, it's his own house to write a memorandum. By the way, when you say the appeal is charged, what's your preposition? Charged of or charged with? You say appeal is charged with sometimes. It should be with, not all. Okay? You might small things like those. It might spell the difference between passing or not passing. Yeah. So be careful to say appeal from adjustment. Now let's talk about appeal. First of all, you must know the modes of appeal. Modes of what? Modes of appeal. How to appeal? Then in civil procedure, you learn that you have what? The first one is ordinary appeal. Did you learn that? Ordinary appeal. And then it can be accomplished by what? By means of notice of appeal or the notice of appeal and report on appeal. So when you say ordinary appeal, it may be by means of what? Notice of appeal. Or, number two, notice of appeal and report on appeal. Alright? Now, this one applies in civil cases. It does not apply in criminal cases. But I'd like to mention it just so we can complete our discussion. Okay? Now, in appeal in civil cases, do you need to file a report on appeal? The answer, no, except in the following. So you need report on appeal only in the following. One, in special proceedings, like settlement of estate. Okay? Number two, in cases involving multiple appeals. Multiple appeals. Or, the third one, separate appeals. So only in these cases do you need to file report on appeal. Otherwise, you don't need a report on appeal. You follow? Now, if the appeal is by notice of appeal, you have 15 days. From notice of the judgment appeal from. But in criminal case, from promulgation. Okay? You understand? Now, if the appeal is by notice of appeal and report on appeal, then the time of appeal is what? 30 days. So this one is 30 days. Because you file a notice of appeal and report on appeal. Go on. Just so you will have an idea. You know, this is not easy to understand unless you can imagine it. The best way to understand this one is to be able to imagine. How does a notice of appeal look like? It should be very short. In criminal case, you have the caption, and then title, and then you say notice of appeal. One word, notice of appeal, and then you say accused by counsel respectfully gives notice that he is appealing from the judgment promulgated by the court on July 1, finding him guilty of homicide. To the court of appeal on the ground that the judgment is contrary to law and the evidence. Signed, counsel for the accused, copy for name, discharge, and then you file this one that is a complete notice of appeal. In criminal cases, you need also to file the appellate, to pay the appellate court copy fee. You understand? That's a notice of appeal. So if somebody tells you, ay, pwede ako, bakit? 2 days na gumagawa kong notice of appeal. My goodness, what kind of notice of appeal is that? It should be very short, no? Okay, now look at this one. Let's say that it can be in civil case or in criminal case. Suppose you file this notice of appeal on time, then you have perfected your appeal. Di follow pa? And then later on, the clerk of court will assemble the record of the case, may mga table of contents, and then it will transmit the record of the case to the what? To the appellate court. It will transmit. Question: ano na iwan sa trial court? Nothing else is retained by the trial court except perhaps a copy of the transmittal letter. You understand that? You follow? Now, so, the record of the case is transmitted to the appellate court. Anong naiwan sa trial court? Wala na. Hello? Ayun. Sir, can you give us an example of a multiple appeal? Example. Have you heard about an action for expropriation? Like a plaintiff files a complaint for the taking of a private property to be used for a public purpose. That is what you call expropriation. Okay? So the steps are, number 1, this is the first stage. Okay? This one is what? A special civil action, as you have learned it in another subject with another lecturer. Okay, so a complaint is filed against the defendant. Now this one, by the way, is incapable of pecuniary estimation. So even if the property is supposed to be expropriated, has an assessed value of only 5,000 pesos, you know what I'm saying, Pat? You file this with the RTC just the same, because an action for expropriation is incapable of pecuniary estimation. Why? Because as you can see in the first stage, the court will inquire into the authority of the plaintiff to expropriate. Now, that is incapable of pecuniary estimation. Assuming that the court finds that in this, the plaintiff has the right and the authority to expropriate, then the court will issue an order of expropriation. It used to be called order of condemnation. Kala nakapatawag mo yun. Kailan they changed it. It's now called order of expropriation. Ayun. Is that the end of the case? No. That's not the end of the case. But can you appeal from this order of expropriation? Yes, you can appeal. But that's not the end. Because the moment the court will issue an order of expropriation, then the case goes into the second stage, which is the determination of just compensation. You know what I'm saying, man? Now look. So down here, the clerk of court will not yet transmit the record of the case to the appellate court. What it will transmit is a record on appeal. You understand? I don't understand that one. Okay, look at this one. So here, the defendant may now appeal from this one. Appeal. Okay? Can you follow? This one is appealable. The order fixing just compensation is also appealable. That's why we call it multiple appeal. You understand? Now look. So let's say that the defendant will appeal from the order of expropriation. What will he find? Well, he will find, number one, a notice of appeal. And number two, a record on appeal. How does the record on appeal look like? Ganito lang yun. Record on appeal. It can be very long because it will state the following. You have the caption and then you say record on appeal. In the old days, that should be printed by a printing press. Now it can be telegraph or computer. Yeah. You know what I'm saying, man? So you say caption, record on appeal. And then you say, defendant respectfully submits the following record on appeal. Number one, you say, caption and title omitted. Number one, that on July 16, 2010, plaintiff filed a complaint against the defendant quoted as follows. Number two, someone was served upon the defendant and in due time he filed his answer as follows. In short, you will only be reproducing the record of the case. You understand it now? And that will be the one to be sent to be transmitted to the appellate court. The question, why don't you wonder, why is it that it is not the record of the case that will be transmitted? Because the case is not yet over. But transmitting record of the case, what record will they use when they go to the second stage? Can everybody now? That's why there should be a record on appeal. You know, this one, a record on appeal. You simply, that's why it should be approved by the court. Question. Does a notice of appeal require court approval? No. What about a record on appeal? Yes, because you might have misquoted some portion of the record of the case. Why don't you transmit the record of the case? Because the case is not yet finished. You understand? There are many things yet to be done, like determination of just compensation. And just to complete our discussion, I'd like you to know that multiple appeals are applicable in, that's number one, expropriation. Number two, what? Partition. And judicial foreclosure of mortgage. Yun. Multiple appeals. A, B, C. You understand? You have any question? Okay. But as you can see that record on appeal is not required in criminal cases. Right? Then number two, you have division for review. This one is Rule 42. Okay? And when it involves wayside judicial bodies, I'm sure you know that. Then you have Rule 43. Then the next one is petition for review of certiorari. And this one is Rule 45. Alright? I have a feeling they will give you a problem involving appeal on Sunday. So just help with that lesson here. It can be very complicated. This one is not easy to understand. Very complicated. Okay? But if, let's say, they will ask you a problem like this one, in the Marxan, let me just show you. Here is the Chief Counsel office, you know. It's also the office of the city prosecutor or provincial prosecutor. They're not called fiscals anymore. They used to be called fiscals, but fiscal, it does not mean anything. Do you know that the word fiscal denotes money? That's why you say fiscal year, So if you go to the States and then you say, hey, I'm a fiscal. You are what? They don't understand that. Those that is sa States, DA, tawag, DA. You know what I'm saying? Okay, now let's say that they would ask you on problem 91. X was charged, X, there's a complaint filed against X for outside at the fiscal's office. So the fiscal conducted a preliminary investigation. And then the fiscal found probable cause. Okay? Question is, what is the remedy of it? Or let's say that X is also the complainant. It can work either way. What is the remedy? Okay, then you take note of this one. Well, first of all, we can file a motion for record, and it's denied. This one is what? The office of the city or provincial prosecutor. If denied, the party aggrieved by the denial may appeal to the DOJ. The DOJ. Okay? Department of Justice. Let's say that the DOJ issues a resolution and you're not satisfied with the resolution. You could be the respondent or the complainant. So let's say you're just the respondent. What's the remedy? Again, the resolution of the DOJ. Can you understand that? The question? Can you understand? Okay. Then you may file a motion for record, and it's denied. You file what? So, motion for record, and it's denied. File a petition for tertiary with a CA. Under Rule 65. Can you understand? Okay, so let's do it again. The office of the city prosecutor issues a resolution adverse to the respondent. The respondent wants to appeal. Then he can appeal it to the DOJ. Let us say that the DOJ issues a resolution and still the respondent is not satisfied. Then the respondent may file a motion for record and if denied, his remedy is to file a petition for certiorari with the Court of Appeals under Rule 65. That is a special civil action. You understand? Okay. Question. Is there any other remedy? Yes. If the penalty for the offense committed is reclusion perpetua or death, although we don't have the death penalty now. If the penalty is reclusion perpetua to death, then the resolution of the DOJ may be administratively appealed to the office of the president. You follow? And then let us say that the office of the president issues a resolution or decision. What is the remedy against such resolution? Answer: a petition for review to be filed with the CA under Rule 43. Don't. It's not complicated. So, this was another one. The DOJ, office of the president, investigate but Rule 43. I have a feeling they would ask that. You know, there was a beautiful girl whose body was found in a drop at the bottom of the sea. Okay?
Paramit.
And then, a case was filed against those suspected of having committed the crime or offense. Do you know what they did? They followed this one. They will change offerings of the great things. So they're now at the city. Yun ang ginamit nila. If you have this one, go to Rule 43 man. You know? Go to section 1. Ito should be understood to have been modified. Kasi, nandiyan pa rin yung Court of Appeals, Court of Tax Appeals, kailangan that's not anymore applicable. Ngayon, if you look at this one, it goes, sabi ko nun, this one, by the way, Rule 43. Appeal from wayside judicial agencies to the Court of Appeals. Sabi natin yan. And then you say, and then you go to section 5. How appeal taken? Did you see that? Section 5, how appeal taken? Sabi ko by means of a verified petition for review. Sabi ko and then it's cool. You go back to section 1. Cool. Then you will see what? Office of the President. Did you see that? Text. Sabi ko, text. Can you text?
Yes.
Then, comma, Office of the President. So, meaning that the resolution of the Office of the President can be appealed to what? To the Court of Appeals. By means of what? By means of a petition for review. Under what rule? Rule 43. You understand ba? Mawasan nyo. If they would ask this in the bar exam, ang pagkakasagutan ay kayo at tagayusin.
If it is not punishable by life, reclusion successful for them, it may not be appealed to them. It cannot be.
It cannot be appealed because the rule is that only when it is punishable by reclusion perpetua or them. Otherwise, your mode of appeal will be the first one that we have explained. Yours. Yours. Okay? Now, let's now go to how appeals are perfected. Okay, we will remove leave this one out, or you leave it. Oh, yeah. Okay. What I will show you appeals in criminal cases. Kung civil cases, more complicated than this one. Much complicated. So, criminal cases. Now, So the case came from the MTC, appealable to the RTC, and then CA, and then Supreme Court. Now, from MTC to the RTC, what is the mode of appeal? By notice of appeal. Let me tell you that if appeal is by notice of appeal, the notice of appeal must be filed with the court that rendered the judgment being appealed from. You don't file it with the appellate court. You file it with the court that rendered the judgment subject of the appeal. Is that understood that? Okay, now. So, appeal to the RTC by filing a notice of appeal with the MTC. So the mode of appeal is by notice of appeal. One. Now, from RTC to CA, the mode of appeal is what? A petition for review. By the way, we're talking about judgment finding the accused guilty. Because if the judgment is a judgment of acquittal, then the accused will not appeal. Okay? You know what I'm saying? Now, from CA to the LD, that is by petition for review on certiorari. There you can raise only questions of law. You cannot raise questions of fact. Because of the CA, you can raise questions of fact, questions of law, or make questions of fact out of law. Because. Alright? Number 2, RTC, CA, and then SP. Meaning that in number 2, the RTC has jurisdiction over the offense. You know what I'm saying? Yeah. Then the RTC rendered a judgment finding the accused guilty, and the penalty imposed is what? Less than death. Reclusion perpetua or life imprisonment. And that. Then appeal is by notice of appeal. Appeal is to the CA by notice of appeal to be filed with the RTC. Alright? Then CA to the NC, this is a petition for review on certiorari. So your appeal from RTC to CA is by notice of appeal. And then number 4, number 2. The penalty imposed by the RTC is what? Reclusion perpetua or life imprisonment. Appeal is to the CA by filing a notice of appeal with the RTC. From CA to NC, the appeal is also by notice of appeal to be filed with the CA. Alright? Then number 4. Number 4 is not applicable as present, but let me just include it. The penalty imposed by the RTC is death. Alright? Then the case goes to the CA on automatic review. So this one is, it goes to the CA on automatic review. Alright? Then, let's say that the CA finds that the penalty of death is correct. Then the CA must render judgment, but shall refrain from entering judgment. Instead, it shall elevate the record of the case to the Supreme Court for review. Did you get that? If the CA finds that indeed the penalty should be there, then the CA should render judgment, but shall refrain from entering judgment and shall elevate the record of the case to the Supreme Court for review. If you are using an old book, I hope you will not use an old book, then you'll find that in the old days, the Court of Appeal in disputation was not as intermediate appellate court. In the old days, if the penalty is life imprisonment or reclusion perpetua, then appeal is to the Supreme Court by filing a notice of appeal with the RTC. Walang say on. And if the penalty is death, then the case goes to the SC for the case goes to the SC on automatic review in the old days. And then came the case of People versus Matthew. Have you heard about that? People versus what? Matthew. In our hometown, we call him Matthew. Ikaw ba? Masarap mo nga sila kay Matthew. They were surprised that in Manila, he is called Mateo. But in our hometown, he is called Matthew. Kakilala nila kay Matthew. Buludog-buludog nila kay Matthew. But in Manila, it's Mateo. Kumanda. Very good. So this is now the case of People versus Mateo. Okay? So, can you see the problem that you file notice of appeal, right? RTC to CA, CA to SC. This one, so, in civil cases, you learned about Napes, diba? Napes versus CA. That's a 2005 case for you in 2005. You were not taking up for yet. That was when Napes role came into being. And then, do you know that in Owen versus you, it was held that the Napes ruling is also applicable in criminal cases. There is no doubt about that. There is no doubt about the application of Napes as to criminal cases. In fact, it also applies when the appeal is by notice of appeal and record on appeal. It also applies. So now it applies to all. But what is this Napes? Okay, look. Let me just briefly discuss it with you. They might ask this one. Question is, in perfecting an appeal, is the filing of a motion for record or a motion for due trial a precondition to the perfection of an appeal? The answer, class, no. It's not. So look, let's say that you receive in a civil case or in a criminal case. From criminal, you count it from promulgation. From civil cases, from notice of the judgment. Okay? Look. So, point 1 to point 2, 15 days. So we don't have to say July 16 anymore. point 1, point 2, 50 days. You follow pa? Alright? Question. Are you compelled to file a motion for record or a motion for new trial? No, you are not. But if you don't file a motion for record or a motion for new trial, then you will have 15 days from promulgation or notice of judgment to appeal. Understand? But if let's say you file a motion for record or a motion for new trial within 15 days from promulgation, and your motion is denied, then you will have a fresh 15 days to appeal from notice of the order denying your motion. That's the naked ruling. Hello? It's called fresh 15-day period. Can you understand? Okay. You are not compelled to file a motion for record. You are not compelled to file a motion for new trials. But if you do, and your motion is denied, you'll have another 15 days from notice of denial of your motion to what? To perfect your appeal. Question. If a party appeals from a judgment, he is not required to file a motion for record or a motion for new trial. Because a motion for record or a motion for new trial is not a precondition to the perfection of an appeal. Question. What are the exceptions? When you must. Otherwise, you cannot appeal if you don't file. Can you understand the question ba? Mawata niyo, no? Ha? Ha? Ay, nakako. The answer, in the following instances, the appellant must file a motion for record or a motion for new trial. Otherwise, he cannot appeal. What are the cases? Number 1, in legal declaration. Number 2, declaration of nullity of marriage. The third one, what do you think the third one? Annulment of marriage. And then the fourth one, in habeas corpus involving custody of minors. You cannot appeal unless you first file a motion for record or a motion for new trial. So in the bar exam, you be careful in the bar exam. Let's say, in an action for legal separation, the plaintiff receives a judgment adverse to him. Within 15 days from notice of the judgment, he files a notice of appeal. And then the question is, was the appeal perfected on time? Or was the appeal seasonably timed? Then the answer is no. Because a precondition to the filing of the appeal, a precondition to the perfection of the appeal is the filing of a motion for record or a motion for new trial. Right? Okay. Habeas corpus involving custody of minors. Kailangan, sabihin niyo pa na, yung involving custody of minors. Kasi kung habeas corpus lang, the time to appeal is what? What's the time of it? Sige nga. In habeas purpose, 4 to 8 hours. Kaya, both habeas purpose lang. Kaya kung habeas purpose involving custody of minors, naman naman yun. Okay? Ngayon. Question. If let's say there is the accused versus the accused, there's a judgment finding him guilty. And then he files a notice of appeal. What is the effect of his appeal on the judgment? Answer: the appeal shall stay the judgment. So what happens to judgment? The judgment is what? It stays. Judgment is stayed. The appeal shall stay the judgment being appealed from. You understand? The question is, suppose you have several appeals, like A and B. A appeals, but B does not appeal. What happens to judgment? As to A, the one who appeals, the judgment is stayed. But as to B, the judgment will become final. Okay? Meaning, the appeal by one or some of the accused will not stay the judgment as to those who did not appeal. Clear ba? Ayun, question. Suppose the case is now with the appellate court, Court of Appeal, and then the appellate court renders a judgment. Will the judgment rendered by the appellate court, will it affect the accused who did not appeal? Will it affect him? The answer was no, except if the judgment is what? Favorable and applicable. Do not forget those words. Favorable and applicable. Don't say, you can say applicable and favorable. But don't say applicable and adorable. Ba yun? Diba? Diba? Okay? You understand that, don't you? Question. May a non-party appeal from a judgment? Non-party is not a party, but you would like to appeal? Pwede ba? No, he cannot appeal. Only parties can appeal. They can ask you this problem. Pagka ito yung problem na tatanungin nila, But first, let me give you some preliminaries so we understand. Of course, you know culpa criminal. You know that in culpa criminal, the liability of the employer is subsidiary. You understand? He becomes liable only if the employee is insolvent. Like here is this is a case involving Philippine Rabbit. You know Philippine Rabbit? That's a bomb. Philippine Rabbit. This is a case involving Philippine Rabbit. And in the old days, they ran like hell. The highways, they ran like hell. So there was this bus that turned turtle. And then the headline the following day said, Philippine Rabbit, third turtle. No American, no. American. This is miracle. Yung nabalik-balik sa taga niya, in English you say, it's third turtle. O yung Philippine Rabbit Band, at ganyan-ganyan, kaya yung headline, sabi hindi, sabi gano'n. In bold letters, Philippine Rabbit, third turtle. Yung nakabasa ng taga-California, this is unhuman. Sabi ko, great, ngayon. Just to wake up. Tulog na this is the employer. This is the employee. And then within the scope of the task, while performing the task assigned to him, the employee committed an offense like reckless imprudence resulting into homicide. So there was a case filed against the employee. It's a criminal case of reckless imprudence resulting into homicide. You understand that? And then the employee was found guilty. And aside from the judgment finding him guilty, there was also an order in the judgment directing him to pay to the heirs of the victim some 1 million pesos. 1 million. Okay? You understand? Instead of saying the judgment becomes final, let us say, then a writ of execution will be issued against the employee, and if the writ is returned unsatisfied, then besides, the subsidiary liability of the employer may now be enforced. Can you understand that? That the employer may become liable subsidiarily in culpa reclam. You follow? Ngayon, let us say that this is now the 15th day to file the notice of appeal. And the employee cannot be found. Question: may the employer file the notice of appeal? He will be the one to appeal. Sabi niya, ay, delikado na ito. Sapagkat, yung liability niya, magiging liability ko. But where is he? I could not locate him. Can I file the notice of appeal? Sabi niya sa inyo, what will you tell him? The answer back, no, he cannot appeal. Because only a party can appeal from a judgment. Katalasan na yan, kaya kasi kumukuha ng driver na hindi matino. Yan, you know what I'm saying, man? Yun ang decision na Supreme Court. By the way, let me also show you the following. You know, Sandigan Bayan. We talked about that early this morning. So let's say here is the Supreme Court, and then Sandigan Bayan. Okay. In number one, because it's number one, the Sandigan Bayan imposes or affirms a penalty less than death, reclusion perpetua, or life imprisonment. Okay? Can you see this one? In number one, the Sandigan Bayan imposes or affirms a penalty less than death, less than reclusion perpetua, less than life imprisonment. What is the mode of appeal? It is a petition for review or certiorari to be filed with the Supreme Court. That is a verified petition, at saka it must be accompanied by a certification of non-forum shopping. Okay? Is that That's easy to understand? Very easy to understand. Except that you will see the word impotent as a word. Now, when we say impotent, it's because the SB, the Sandigan Bayan, is in the exercise of its original jurisdiction. As we say affirmed, because the Sandigan Bayan is in the exercise of its appellate jurisdiction. You follow? I understand that? Because the case came from where? It came from the RTC. Or it came from the MTC, then to the RTC, then to the Sandigan Bayan. Are you still following? Are you still with me? Or? Okay? So that's why we say the Sandigan Bayan affirmed. Okay? Now, we explained this morning, did we not? That we said that if, let's say, the position is not in Section 4 of Republican 8249, and the employee or government official does not occupy a position equivalent to grade 27 or higher, then he will be tried by the RTC or by the MTC, depending on the penalty. Okay? So, if it came from the RTC, the mode of appeal is what? A notice of appeal to be filed with the RTC, but the appeal is to the Sandigan Bayan. If it came from the MTC, then the appeal is to the RTC by notice of appeal to be filed with the MTC. Then, RTC to the Sandigan Bayan, it is a petition for review. Okay? Number 2, alright, in number 2 pa, the Sandigan Bayan is in the exercise of its original jurisdiction, and it imposes the penalty of reclusion perpetua or life imprisonment. Then appeal into the FD by filing a notice of appeal with the Sandigan Bayan. Original jurisdiction. Okay? Then the third one, the Sandigan Bayan is in the exercise of its original jurisdiction as it imposes the penalty of death. Then the case goes to the Supreme Court on automatic review. Okay? Then the fourth one, the Sandigan Bayan is in the exercise of its appellate jurisdiction. And it imposes the penalty of death, reclusion perpetua, or life imprisonment. Appellate because the case came from the RTC. Okay? Can you understand this one? Now, in the exercise of its appellate jurisdiction, the Sandigan Bayan imposes the penalty of death, reclusion perpetua, or life imprisonment. Then, if the Sandigan Bayan finds the penalty to be correct, it shall render a judgment, but shall refrain from entering judgment, and shall elevate the record of the case to the Supreme Court for review. You put this alongside with the first ones that we wrote on the board, so you can see the comparison. Alright? Take note that, is there anything that you can see here? If it involves a government official who commits an offense in relation to public, then the Court of Appeal is not an appellate court. That's why you cannot see the Court of Appeal in the entire what? Illustration. You don't see the Court of Appeal. Ngayon, in your free time, you might want to scan the Supreme Court decision. And you'll find many cases where the appeal was brought to the Court of Appeal. You know what happened to this appeal? They were dismissed. Because if the appeal is brought to the wrong court, then the only power that court will have is to dismiss the appeal. In one case, class, the Court of Appeal to which the appeal was brought transmitted the record of the case to the Sandigan Bayan. The Supreme Court said the Court of Appeal has no authority to transmit the case to the Sandigan Bayan. The only authority it has is to dismiss the case. Ang daming ganon. The appeals were brought to the Court of Appeal. It was held in these cases that the appeals were brought to the wrong court. That's why, if they would ask you on Sunday, a problem involving appeal, and the appeal in the problem is a government official charged with an offense committed by him in relation to his office, then as you can see, the Court of Appeal is not an appellate court. So, bro, RTC, you don't appeal to the CA, you appeal to the Sandigan Bayan. RTC, you don't appeal to the CA, you appeal to the Sandigan Bayan. Kahit na dito, kahit na yung MCC, RTC, you don't go to the CA, you go to the Sandigan Bayan. Alright? Then we go to evidence. That was also included in my assignment. Although originally it's only free throw, but I was told to stay overnight with you up to 12 midnight to discuss evidence. But you have questions to ask?
Sandigan Bayan, Sandigan Bayan exercises its appellate jurisdiction. Yes, sir. What I understand, sir, that after the Sandigan Bayan rendered decision, the word request, sir, that the Sandigan Bayan will not intercept in the next, but that decision to the Supreme Court.
Well, the thing that it's the same thing that I told you. If the appeal is to the Sandigan Bayan, okay, this one is the case came from the RTC, can you see that one? And then appeal to the Sandigan Bayan. If the Sandigan Bayan finds that the penalty is correct, it will simply render judgment but shall refrain from entering judgment. Meaning, the judgment will not become final in the meantime. Because there is no entry of judgment. so it will not be final in the meantime because Sandigan Bayan will elevate the case to the Supreme Court. Yes, well, you don't have to do anything for the Sandigan Bayan to elevate it to the Supreme Court. Yeah. So you just have to take note of this one, AJ, OJ, no, ano bang OJ? Don't say OJ Simpson. Let's have a break and then when we come back we will talk about evidence. It's the evening, like 5:30. Well, yes, like the big soul. It's for you to do this one, but there's no hard to do Well, all of you know the definition of evidence, I'm sure. So let's talk about evidence now. I'm sure you have heard about the role of DNA evidence. Diba? What is DNA? The ribonucleic acid. You know that? It took me 9 months to memorize that one. The ribonucleic acid. DNA. If you don't know the meaning of DNA, then you say, di niya alam. DNA. Di niya alam. In Ilocano, di na amo. So this is di na amo. Di niya alam. DNA. Alright? Now, it has been said that in cases involving alternatives, take note that no two individuals have the same DNA except perhaps identical twins. Yeah. And DNA evidence may be resorted to prove paternity. Yeah. Paternity, what else? The identity of a person, and then the commission of a crime. So DNA may also be used to identify an individual. Identification. Yeah. In cases involving paternity, if let us say a DNA test is conducted, and then the result does not match, then what does it mean? Well, the result of a DNA examination that shows non-paternity is conclusive evidence of non-paternity. So if the result will show that the putative parent is not in fact the parent of the child, then that is a conclusive evidence of non-paternity. Conclusive evidence of paternity. Alright? That's the way to write paternity. Don't write it this way. You know, this one. So if the result excludes the putative parent, you know what I'm saying? Then that is what? A conclusive evidence of the paternity. Meaning, the person alleged to be the father is not in fact the father. So, but then, if the value of probability of paternity, you call that value of probability of paternity, is less than 99%. Less than 99%. Then that is what? Corroborative evidence of paternity. If you conduct a DNA examination and the result will show that the value of probability of paternity is less than 99%, then that is what? Corroborative evidence of paternity. But if it is 99% or more, then there is a disputable presumption of paternity. Disputable presumption of paternity. So the presumption is what? Disputable. Alright? A while ago we said that if there is a judgment of conviction, okay, then the accused still has remedies against that judgment. One of them is appeal. We said that a while ago. Remedies against a judgment of conviction. But suppose the judgment is now final. It's now a judgment that has become final. The question is there still a remedy against that judgment that has already become final? Yes. And the remedy is what? A petition for habeas corpus. Go on. And if you look at the rule on DNA evidence, let's say that the judgment is now final, and the accused is now serving sentence. He's not only an accused, but is now a convict, doing his time. Okay? Then, there may be a DNA examination. A DNA examination may be conducted. Upon whose request may be conducted, upon the request of the convict himself or by the prosecution. The prosecution may ask that a DNA examination be conducted. It may be asked, who can ask that a DNA examination be conducted, the convict or the prosecution? Question, in this situation, is there a need for a court order so that a DNA examination can be conducted? The answer, class, no. There is no need for a court order. Alright? But then, it must be shown that what? You have all the following. that there exists a biological sample. There is a biological sample. There exists a biological sample. That biological sample is relevant to the case. And the result of the DNA examination is likely to cause a reversal or modification of the judgment of conviction. If you have all of these, then a DNA examination may now be conducted. Okay? Existing of DNA sample or biological sample that it is relevant to the case, and the result is likely to cause a reversal or modification of the judgment of conviction. So it is to recall. But, question. Suppose the result of the DNA examination is favorable to the accused. What then is the remedy? Remedy class is one. A petition for habeas corpus. And that petition may be filed with the state court that rendered the judgment of conviction. It may also be filed with the Court of Appeals or with the Supreme Court. But take note that it can be filed with the court that rendered the judgment of conviction. And then, if the court finds that indeed, based on the result of the DNA examination, the court finds that the accused did not commit the offense, then it will set aside the judgment of conviction and order the release of the accused from detention. Understand? Question. Who can file the petition for habeas corpus? The accused himself may file the petition, or the prosecution may also file the petition for habeas corpus on behalf of the accused. So this time it is the prosecution filing the petition for habeas corpus on behalf of the accused. Alright? So this one is called post-conviction remedy. Alright? Of course, do not forget yung mga terms na facto, probando, facto, proba. Kaya, don't forget those. Falso is uno, falso is optimal. Kaya, don't forget. Okay, now look. There are matters that do not need evidence. So we say evidence is the means sanctioned by the rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. That's the definition of evidence. And then, requisites of what? Admissibility. It must be both competent and relevant. So it must be what? Competent and relevant. Competency and relevancy. So, evidence is said to be competent if it is not excluded by the rules. Then it is competent. And we say that it is relevant if it has such a relation to the facts in issue as to induce belief in its existence or non-existence. Then it is relevant. Even if relevant If not competent, it is not admissible. So both of them must be complied with. The requisite of being competent and the requisite of being relevant. Alright? You understand that? Like, I'm sure you have heard about Republic Act 4200. But that is the Anti-Wiretaping Act. Anti-Wiretaping Act. So, this law prohibits what? The secret to secretly overhear, intercept, or record private communication without the consent of all the participants. So let us say that I am having a conversation with someone, and then there's somebody who is recording my conversation with that someone without my consent. This guy is also giving me some answers. He did not also consent to the recording of the conversation without the consent of all of them. Then that is not admissible in evidence. So like, sometimes some people will come to you and then they will ask you, this guy owes me some money, but I don't have evidence. And I go to him and then I will record the conversation without him knowing it or he cannot. Then the answer is no, because that one is not admissible in evidence. You understand? That violates the anti-wiretaping law. What is prohibited is to secretly overhear, intercept, or record a private conversation without or communication without the consent of all of them. By means of what? By means of walkie-talkie, by means of a tape recorder, dextaphone, dextagraph, or the dextaphone. Honestly, I only understand walkie-talkie and tape recorder. Dextaphone, the dextaphone, dextagraph, I don't understand anything more. Okay? So that is not admissible. Now look, what happens if you violate this law? If you violate this law, that is a criminal offense. Then, in the prosecution of the criminal case against you, that is admissible in evidence. You understand? Just to prove that you violated the law. Okay? I'd like you also to take note that there are certain matters that do not need evidence. And these are, number one, judicial notice, or matters that can be taken judicial notice on, or simply judicial notice. And then number two, judicial admission, or matters that are judicially admitted. And then the third one, presumption, or matters that may be presumed. They do not need evidence. Like if something can be taken judicial notice of, then you don't have to present evidence to prove it. Like measures of time. Or what? Or the political history of a nation. That can be taken judicial notice of. Like political infractors in the Philippines. And then if you say, I filed my case with the regional trial court in Baguio City. Pag mo ka then you don't have to present evidence to show what is that regional trial court, where is Baguio City, because the court is supposed to know all of this. These are matters that can be taken judicial notice of. You understand? The colors or emblem of our country, that can be taken judicial notice of. Okay? But the question in the bar exam, very likely, may our court take, by the way, our court must take judicial notice of our own law. As when you say, Batas Pambansa Bilang 22, you don't have to show a copy of the law in court. You don't have to say, Your Honor, please, I have a copy of this law. I hope that it be marked as Exhibit 8. You know, people of the court must take judicial notice of our own law. But the question is, may a court take judicial notice of municipal ordinance? Well, if the municipal ordinance is an ordinance of the municipality where it is situated, then it must take judicial notice of that ordinance. But it's not the same. The city ordinance involves in a litigation. If the city ordinance of Manila, for example, but the litigation is in Baguio, then the court in Baguio cannot take judicial notice of the municipal ordinance in Manila. You understand that? Okay. Well, may our court take judicial notice of a foreign law? Let me put it this way. So here is the plaintiff against the defendant. Plaintiff files a complaint and his cause of action is based on a deed of sale. Okay? Deed of sale. Now, that deed of sale must be pleaded in the complaint. It must be pleaded as a fact, and it must be proved as a fact, unless the defendant will admit it. Then it must be pleaded as a fact, it must be proved as a fact. You follow that? Now, in the case of a foreign law, this one is a foreign law, our court cannot take judicial notice of a foreign law. It must be pleaded as a fact, and it must be proved as a fact. But it's the same matter as a deed of sale. You understand that? It must be pleaded as a fact, it must be proved as a fact, because our court cannot take judicial notice of that foreign law. But then, if the foreign law is not pleaded as a fact, and it is not proved as a fact, then the presumption is that it is the same as our law on the matter. What is the presumption? The presumption is that it is the same as our law on the matter. That is known as what? The doctrine of presumed identity approach. What do you call that? You call it the doctrine of presumed identity approach. Otherwise known as process-plus presumption. At also dito, yung process-plus, diba? Everybody knows that, but when you say, is that also the same as presumed identity approach? Yung mga iba, inanilala. But this one is the same as the doctrine of process-plus. You write the word process, and then you add UAL. Process-plus. presumption. Pag ito Martha, they might ask you that. Explain the doctrine of presumed identity of groups. That's the same as perpetual presumption. Right? Okay, so let's talk about, there are many ways of classifying evidence. Do you know that? You can say affirmative, negative, yeah. You can say direct, circumstantial. There are many ways of classifying them. Okay? But the most common way of classifying evidence is to say object evidence according to nature, object evidence, documentary evidence, and testimonial evidence. So let's talk about object evidence, documentary evidence, and testimonial evidence. Object evidence used to be called real evidence, but we more call them evidence of autopsy prophecy. It is that kind of evidence that can be exhibited to or viewed by the court. Like a gun, for example, to prove the existence of a gun, it can be shown in court. So the object evidence, an object evidence is what is read to the senses of the court. Sense of sound, sense of taste, and so on. Alright? You understand? That is what? Object evidence. Sometimes known as real evidence. Yours. Okay? Now, if a deed of sale, may a deed of sale be an object evidence, deed of sale? Well, if the purpose is to prove the existence of that deed of sale, then it is an object evidence. Because the purpose is to prove its existence. But if the purpose is to prove the content of the deed of sale, then it is a documentary evidence. In the same way that is from a God, and the purpose is to prove the existence of the God, and the word that it is the same God used in the commission of the crime, then that is an object evidence. But if the purpose is to prove the writing on the handle of the gun, you know what I'm saying, man? Might have been engraved on Tu Ave, I love you. Okay, now, on the handle of the gun. And the purpose is to prove the writing on the handle of the gun, then it becomes a documentary evidence. So you have a gun that is a documentary gun. You understand? So in that sense, the gun becomes a document. Alright? We understand that? Let's go to documentary evidence. Well, documentary evidence is any material containing letters, words, numbers, figures, or any written mode of expression, offered as proof of its content. Yeah. So look at this one, offered as proof of its content. And then, when we say documentary evidence, two things will come to mind. The first one is the best evidence rule. And the second one is what is called as parole evidence rule. The best evidence rule is applicable when the subject of inquiry is the content of a document. Okay? So what is the subject of inquiry? The subject of inquiry is what? The content of the document. Then the only evidence admissible is the original of the document itself. That's the best evidence. No evidence is admissible other than the original of the document. You understand that? So you might be asked, what is the original of a document? Then you have to be guided by the following. Number one, the original of the document is what? The contents of which are the subject of inquiry. Number two, when the documents are executed in 4 more copies, when the document is in 2 or more copies, executed at or about the same time, with identical content, then all such copies are to be regarded as original. Like when you make a little thing, you don't only have 1 copy, you have so many copies. Executed at or about the same time. So it's okay if you sign it 1 copy at a time. All of them are to be regarded as original copies. And when an entry is repeated in the regular course of business, one being copied from the other at or near the time of the transaction, then all such entries are to be regarded as original. Okay, so that is the original of the document. So look at this one part when the best evidence rule applies when the subject of inquiry is the content of a document. So that if the subject of inquiry is not the content, but the existence of the document, then you don't apply the best evidence rule. Alright? Okay. Now, what are the exceptions? Exceptions when secondary evidence is admissible. So what are secondary evidence? You have the following copy of the document. Number 2, recital of its content in some authentic writing. And then the third one, testimony of witnesses. These are the secondary evidence. Now take note that even among secondary evidence, there is an order of reference. You cannot present the second one unless you have accounted for the first one. You can show that there is no copy of the document. Then you can go to the second one. Okay? Can you understand that? Now look at this one. So the original copy is the best evidence. Original. So the best evidence rule excludes or prohibits the presentation of secondary evidence unless you fall under any one of the exceptions. Okay? But if you don't fall under any of the exceptions, then you cannot present this secondary evidence. you have to present the original copy of the document. That's why when you go to the bar exam on Sunday, you must be able to recite to yourself the exception. Okay? Number one is what? When the original has been lost, destroyed, or cannot be produced in court without bad faith on the part of the author. That's a very difficult word to say, on the part of the author. Number two, when the original is in the custody of the party against whom it is to be presented and he fails to produce it after reasonable notice. Okay? And the third one is when the original consists of numerous accounts or documents which cannot be produced in court without great loss of time. And the fact to be established from them is only the general result of the whole. And then the last one, when the original is a public record in the custody of a public officer. You have to memorize all of them. Okay? Before you go to the bar exam. Because they have simply asked. You have to present the original of a document. What are the exceptions? And you have to mention 1, 2, 3, and 4. How do you explain the first one? When the original has been lost, destroyed, or cannot be produced in court without bad faith on the part of the author. Then, to be able to present secondary evidence is also called substitutionary evidence. Okay? You must prove, number one, the due execution and existence of the original. You have to prove it. The existing and due execution. And then number two, the law or infraction of the original. And if the original is in several copies, you have to account for all of them. And then, the third one, the efforts exerted to locate them. But all these efforts prove disputed. Then you may now present a secondary evidence. Okay? So you execute existence and due execution, the law or the fraction, etc. The third one, when the original is in what? Consists of numerous accounts or documents, which cannot be examined in court without great loss of time. And the fact sought to be established from them is only the general result of the whole. What could be an example of this one? Like, you were hired to build a house, you're an architect, you were hired to build a house for 10 million, then you build the house, but the owner does not believe that you put into it 10 million. You say, this is only 2 million. You say, that's 10 million. Then, as a client, you now go to court with 10 truckloads of receipts, just to show that you spent 10 million. Then you now start saying, Mr. Witness, I show you this receipt in the amount of 10 pesos and 50 centavos. What is it? I bought that, I used that for buying names. Imagine, you will present all these evidence, these documents. So, it cannot be examined in court without great long of time. And the only thing that you need to know from them is the total amount. You know what I'm saying, class? Then you don't have to present all the original receipts. That is the third exception. Okay? Now, have you heard about the electronic data message? Electronic data message. That is the other name of what? Electronic message. Electronic document. The same as electronic document. So in the diagram, you see the word electronic data message. That don't get too excited. That only means electronic document. Then the question is, what is the original of an electronic document? What is the original of an electronic document? Then the answer class, it is the output or printout, readable by fax. So the printout, you know what I'm saying, printout? That's the original of the electronic document. Okay? Now, if I go to our,
What about the soft copy?
we'll go to that. If I go, let us say, to a machine operator, and then I show him a document. Let's say that this one is a document. It's not a document. It's an iPad, but let's say it's a document. They don't say. And then I tell him, can you make a copy for me? You know what I'm saying, class? Then he makes one copy. Then this is the original. That one is simply a copy. So this one is the original copy. You understand? Now, let's say that you are sending to me a copy. I am in Baguio. You're in Manila, and you're sending to me a copy through what do you call that? A fax machine. You know what I'm saying? Fax machine? Okay. In Baguio, they don't understand fax machine. That's why it's so difficult to explain the class to them. They are coming from all over the mountainside, you know. Yeah. So you are in one office. I am in my office in Baguio, and then I told you, can you send me a copy through fax machine? Then in just less than 15 minutes, I already have my copy. That you send through the fax machine. You understand what I'm saying, Juan? Question: is that an original? I go to court and then your Honor, please, I move that it was remarked in evidence as our exhibit. Yeah. What's that? Well, this is an original that came from a fax machine. Can I say that? The answer was no, because look, it's just the same as the first example where you go to a copying machine. You understand? It's just that it was sent through a telephone line. There is what you call an original paper-based information. You know what I'm saying? So there in Manila, when you send a copy to me in Baguio, you are using an original paper-based document or instrument. Yeah. So the copy that came to me through the fax machine, that's not an original copy. It's just the same as what? play machine copy or 0. Yun. Okay? What about, let's say that you are using an Underwood typewriter. You know Underwood typewriter? Okay? This one is 1951. You use Underwood typewriter. Yung mga letters may tumataas pa. Okay. And then I have a copy of that digital thing. Okay? Question. Is that an electronic document? Yeah. The answer class, no. That is not an electronic document. But it may become an electronic document if what? If recorded or transmitted electronically. Oh. Understand? What about this, we call ephemeral electronic communication? Are they admissible in evidence? Yes. And how can it be proved in court? By the testimony of a person who is a party to it, or testimony of a person who has knowledge thereof. Do you know what is meant by ephemera? Something that cannot be kept permanently. It's what? Very temporary. Example, text messages. Yeah. You don't keep the text messages all the time. So that is an example of ephemera electronic communication. Admissible? Yes, admissible. There's no doubt about that. But they might ask you a question like, is a text message admissible in evidence? Then you say, yes, this is an example of ephemeral electronic communication. And it is admissible in evidence. Alright? Then we have the next one, parole evidence rule. Yeah. The way to understand this one is to define some terms. When you say parole, it means what? All round. That is what it means. Parole. All round. The word aura can be understood in so many senses. One way to understand aura is to think of Monica Lewinsky and this is aura. Malaki ba yun? That's very bad. Yung ibang aura, yung as opposed to written. By the way, ang opposite ng written is what? Aura. It's not verbal. Kasi yung verbal, written is also verbal. You know what I'm saying, class? Yung mga iba kasi, it was verbally made. Oh, yung written, that's also verbal. Ang opposite ng written is aura. Okay? What's the opposite? Look, parole, aura. When you say parole evidence, this means evidence adjunde, or evidence that is outside the document. You know, evidence adjunde, or evidence that can be found elsewhere outside of the document. You know. And then when you say parole evidence rule, that is the rule that tells us that when the terms of an agreement have been reduced into writing, then it is understood as containing all the terms agreed upon. And there can be between the parties and their successors in interest no evidence of such terms other than the content of the written agreement. You know what that means, huh? Yeah. So let's say that this one is a memorandum of agreement between X and Y. Then it is understood that this MOA contains all the agreement between X and Y with respect to the subject matter of this agreement. And therefore, no parole evidence is admissible to modify, to vary, or to change or to alter the terms of this agreement. You understand what I'm saying, man? When the terms of an agreement have been reduced into writing, it is understood that it contains all the terms agreed upon. So, these rules prohibit what? What does it prohibit? The varying of the terms of the agreement. You follow? Right? Let's say that X is now on the witness stand testifying. And then he presented this MOA. I have an agreement with the defendant in this case today. And then he's now asked a question like, aside from those stated in the MOA, what other agreements did you have with the defendant? Can you check to that question? Yes? You'll check on the ground that what? You cannot vary the terms of the written agreement. A written agreement, the MOA, is understood to contain all the terms of the written agreement. You understand? So, while the PER prohibits the introduction of secondary evidence, the PER prohibits the varying of the terms of a written agreement by parole evidence. You follow that? Let me tell you also that the PER, okay, applies to all documents or writing. Does it apply to a demand letter? Yes. Okay. Does it apply to a memorandum? Yes. Does it apply to legal things? Yes. But this one, PER, applies only to what? To contractual or to what? Applies only to contractual agreements. Yeah. I hope you understand what I am telling you. Except as to will. It applies also to a will, and a will is not a contract. But the PER applies to a will. And then aside from this, as an exception, it applies to all agreements. So the PER does not apply to a demand letter because that is not an agreement. Okay? And then the best evidence rule applies even if the litigation is between individuals or not parties to the document. But the parole evidence rule applies only if the litigation is between parties to the written agreement. Okay? Like, let's say that this is between X and Y, but then X files the case against Y and Z, and Z is not a party to this, then the parole evidence rule no longer applies. You understand? It applies only when the litigation is between parties to the agreement. Okay? There are exceptions also. Like what? What are the exceptions? But for the exceptions to be applicable, the party must put an issue in its pleading. Yeah, now look at this one. He must put an issue in his pleading. Number one, the intrinsic ambiguity, mistake or imperfection of the written agreement. Intrinsic ambiguity. What else? The failure of the written agreement to express the true intentions or agreement between the parties. Then the third one, the validity of the written agreement. And then the last one, existence of other terms agreed upon after the execution of the written agreement. But for any one of these exceptions to be applicable, the party must put it in issue in his pleading. Intrinsic ambiguity is also known as what? Latent ambiguity. What is the opposite of intrinsic ambiguity? Extrinsic ambiguity or latent ambiguity. Now look, what is this intrinsic ambiguity? Well, the document is very clear. There is nothing wrong about the agreement. It is so clear. But the ambiguity is in the person, object, or thing mentioned in the agreement. Can you understand that? Right. If you look at the document, it's perfect. Tenses, grammar, perfect. Ambiguity, not ambiguity. But the ambiguity lies in the person, object, or thing mentioned in the agreement. You understand? Then that is what? Intrinsic ambiguity. Then you can present parole evidence to prove your cause of action, to show that, to remove the ambiguity. Example. Let's say that I make a beautiful deed of donation. Donation mortis causa. Yeah. And the name of the donee is Ray Mendez. So I write Ray Mendez. You know what I'm saying? That's the donee. And then I die. Then the donation takes effect. You understand? And then one person comes and he tells you, he is Ray Mendez. He shows you a certificate of birth. And then another person comes and he tells you, I am Ray Mendez. Oh, how come you're also Ray Mendez? And then another one comes, I am Ray Mendez. Now this time, there is now an ambiguity. You understand? The document is clear, but the ambiguity is in the person mentioned in the document. That is what you call intrinsic ambiguity. As parole evidence is admissible to prove who is being referred to as Ray Mendez in that deed of donation. You understand? Okay. What else do we need to explain? Alright? Well, you know that a person can testify only to facts known to him of his own knowledge. Okay? if he goes to court, and then he will testify, how did you know that it was Abe who killed Romy? And then you say, because my teacher told me that it was Abe who killed Romy. Then that's hearsay, and it's not admissible in evidence. Hearsay. Okay? Now look at this one time. When we say hearsay, what is hearsay? Hearsay is a statement made outside the court. Made outside what? Made outside the court. And offered in court to prove the truth of the statement. Then that is hearsay. It is a statement made outside the court. Okay? But it is offered in court to prove what? The truth of the statement. In short, that is hearsay. Uy, alam mo, si ganito, ay pa niya si ganito. Then, nadinig mo gano'n, and then you now go to court. Si ganito, ay pa niya si ganito. How did you know? Somebody told you about it. Then that's hearsay. Understand? It's a statement made outside the court and offered in court to prove the truth of the statement. Yeah? So if they would ask you to define what is hearsay, then that's the one. Hearsay. Alright? Don't make it very long. Then, when you say hearsay, how do you spell hearsay? You first write the word hear, and then the word say, and then join them together. Like a friend of mine was telling me yesterday, remember him, remember he. Put them together, remember he. Okay, my goodness, affordable naman. So, write here, and then write, say, put them together, it becomes hearsay. Okay, now, so let's talk about the statement made outside the court. Number one, you have hearsay. Hearsay statement. Number two, non-hearsay statement. And then the third one, hearsay statement, but admissible in evidence. By hearsay statement, but admissible in evidence. Yes, like dying declaration. Is that hearsay? Of course, yes. It is a statement made outside the court, and then it is now offered in court to prove the truth of the statement. That is hearsay. But what? It is admissible in evidence. So hearsay statement. If I were the examiner, I would not ask something like that. That's very easy. But I would ask something like, I will go to deposition, for example. You know deposition? You know deposition? Whose deposition can be taken? You understand the question? Like now, X versus Y. X the plaintiff, Y the defendant. The question is, whose deposition may a party take? Well, it can be the deposition of a party or a deposition of a person not a party to the action. Can you understand that? So if, let's say you are the plaintiff X, can you take the deposition of Y? Yes, you can take the deposition of Y? Can you take the deposition of W, who is not a party to the action? Yes, also. You understand? Most of this coverage. Maganda. Deposition pending action. Deposition before action. Maganda. What is deposition pending action? That's called deposition depending ethics. Yung before action, deposition in perpetuam re memoriam. So if they would ask you in the bar exam, what is this deposition in perpetuam re memoriam? That sounds like my name, Ray. Re memoriam. Then that is deposition before action. Even before you can file a case, you can take the deposition of a person. That is called deposition in perpetuam re memoriam. Okay? Ayun. Suppose plaintiff took the deposition of Y. And then he took also the deposition of W. Okay? You know what I'm saying, class? And then, at the trial of the case, X presented the deposition of Y to prove his claim. And then he presented the deposition of W to prove his claim. You know what I'm saying, class? He's using it as evidence. Question: if X will now present the deposition of W as his evidence to prove his claim, what objection can you make if you were defendant Y? You can object to the presentation of W's deposition on the ground that it is hearsay. You understand? That is hearsay. Okay? Just like you make an affidavit, and then they will present your affidavit in court. Of course, that is hearsay. This deposition is no better than an affidavit. Okay? You understand? So, they would show you a problem like this one. X took the deposition of W, and then at the trial of the case, in W's deposition, he mentioned that Y obtained a loan from X in the amount of 2 million pesos. That is the deposition of W, and he knew it because he was present when Y borrowed the money from X. So X is now presenting W's deposition as his evidence. Is that admissible? No, because that is hearsay. Okay? You have any questions? Perhaps we should extend the discussion. If the deposition is a deposition of a party, for what purpose may the other party use that deposition? Answer: it can be used for any purpose. So if X takes the deposition of Y, then X can use Y's deposition for any purpose. Okay? But if the deposition is the deposition of a person, not a party to the action, like W, then the only purpose the plaintiff can use the deposition is to impeach or contradict him if he testifies. Only for the purpose of impeaching or contradicting him. Understand? So that like here, W will now testify either as witness for X or witness for Y. And then we'll say, oh, walang utang po si Y kay X, walang utang. And then he can now be impeached with the use of the deposition. Prior inconsistent statement. Diba? That's the only purpose. For the purpose of impeaching or contradicting him. So if let's say W is available to testify, you cannot use his deposition as evidence. You can use it only for the purpose of impeaching or contradicting him. You understand? Yeah. But if it is the deposition of a party, it can be used for any purpose. Like what? Ano bang ibig sabihin ng any purpose? As evidence or for the purpose of contradicting or impeaching him. But if the deposition is the deposition of a person not a party to the action, it can be used only for the purpose of impeaching or contradicting him. Except if the witness is dead. Outside the Philippines or unable to testify because of his person. Or he resides more than 100 kilometers from the place of trial. In a civil case, can you compel a person to testify if he lives more than 100 kilometers away from the place of trial? No, you cannot compel him. He can invoke his right, known as the violatory right of a witness. Violatory right. That was asked in one more example. What is violatory right? That is the right of a witness not to be compelled to testify if he lives more than 100 kilometers from the place of trial. Then, in these instances, is dead outside the Philippines, etc., then you can use his deposition for any purpose. Right? Well, now hearsay. Now hearsay. It's a statement made outside the court and presented in court, and it can come within the meaning of a non-hearsay statement if it is one, an independently relevant statement. Have you heard about that? Independently relevant statement. When you say independently relevant statement, the statement is being offered in court not to prove the truth of the statement, but to prove that the statement was made. Okay? Can you understand that? Like, in a case for grave oral defamation, for example. So this one is saying while X is at the public plaza, and there were many individuals present, among them was W, X mentioned to everybody there that Y is magnanakaw. Alam niyo, si Y ay magnanakaw. Marami siyang dinakaw. Kaya siya mayaman, maganda ang kotse kasi siya ay magnanakaw. Sabi ko, napakinggan ni W. And then, there's now a case filed against X, grave oral defamation. The complainant is Y. You understand? And then W is now on the witness stand as a witness. And then a question is put to him. What did the egg say at that time? What did he say? To God. Then, check objection. That is hearsay. God, is it hearsay? Well, the purpose is to prove not the truth of the statement, but the fact that the statement was made. That is what? The statement is the fact in issue. When the statement is the fact in issue, the fact in issue is not the truth of the statement, but the fact that it was made. That's the fact in issue. Then it is an independently relevant statement. It is being offered not to prove the truth, but to prove that the statement was made. You follow? Or the second one is what? The statement is what? Circumstantial evidence of the fact in issue. Then it is also an independently relevant statement. Like in a petition for guardianship, and in that petition, X is alleged to be insane. Okay? So that's the purpose of the petition, to have a guardian appointed for X, because X is alleged to be insane. Okay? You know what I'm talking about, that? You understand? And then, one of the witnesses presented was W. And then he's now on the witness stand. And when you were at the public plaza, what happened? Then W said, I saw X on a platform. And what was X doing at that time? His hands were stretched into the sky. And he said something. What did he say? He said, I am the Messiah. I came to save mankind. Okay? That's what he said? Yes, sir, that's what he said. Then, can you check on the ground that the statement is hearsay? Not hearsay, he's not the Messiah. No. Well, that is not hearsay. You understand? So, it is being offered to prove that X is insane. It is a circumstantial evidence. The statement is being offered as a circumstantial evidence to prove the fact in issue. What is the fact in issue? The sanity or insanity of X. And the statement is being offered to prove that fact in issue. You understand what? You call them what? Independently relevant statements. How do you write that again? Independently okay? When you say independently relevant statement, you can group this statement into two. The statement is a fact in issue. You offer it not to prove the truth, but to prove that it was made. And then the second one, the statement is a circumstantial evidence of the fact in issue. So suppose you'll be asked in the bar exam on Sunday, what is an independently relevant statement? That should be easy to say. An independently relevant statement is a statement that is relevant independently of whether or not it is true. You just move forward and then move backward. An independently relevant statement is a statement that is relevant independently of whether or not it is true. Because the truth of the statement is not the fact in issue. There's a lot, No, it's very easy. That's why I took a photo because it's very easy. Yeah. Alright? You need a break? Break, and then we come back. Are we coming back here? No more? Because if you say no more, then that's the end of the discussion. But if you say, let's move on, then let's move on. But let's have a break and then we come back. We were talking about hearsay a while ago, a statement that is made outside the court. I'd like you to take note that when it comes to what? To an act of child abuse or attempted act of child abuse. Alright? The statement of a child describing an act of child abuse or an attempted act of child abuse is admissible in evidence, although hearsay. Yeah, like here is a child, 6 years old, and then he tells, let's say, his auntie that somebody has hurt, okay? Hinibuan po niya ako. Kaya, kahapon. Question, can the auntie testify in court about the statement of the child? Is that hearsay? Yes, hearsay. But the rule tells us that the statement of a child describing an act of child abuse or attempted act of child abuse is admissible in evidence, although it might be hearsay. Class, you will find it in the rules of examination of a child witness. Okay? Is a child witness, may a child testify as a witness? Yes. But if the court has reasons to doubt the ability of the child to perceive and to remember what she has perceived and to relate it in court, then the court may conduct what is known as a competency examination to determine the ability of the child to remember and to relate what he could remember. And if he recognizes the duty and obligation to tell it honestly in court. Okay? That's why there will be some preliminary questions like, do you know what will happen to you? Is it good to tell a lie? You know what I'm saying, class? Is it good to tell a lie? Hindi po. Uy, okay po. What will happen to you if you tell a lie? Then he will say, I will become a counselor po when I become old. Oh. You know what is, he understands the meaning of an oath, diba? Do you know what will happen to you if you tell a lie? Do you know what will happen to you if you are always lying? Yeah. Magiging konsihal po ako. Ayos po Ayaw mo sa isika. May mga counselor pa ito Power science. Delete. Great. Sabi nyo sa akin. May tawag ito Sabi niya. 1/2 of those invisible are dishonest. Sabi niya sa publiko niya. one half of those people, individuals, are dishonest. Then my book tells I will sue you if you do not change your statement. Pinalitan niya, sabi niya, one half of those people, individuals, are honest. Oh. Sabi ko yung buta, pwede yung gusto mo. Ayun, di ba? Okay na. Isip ka ngayon, di ba? Look at this one. Rule on examination of a child witness. Here you will also find what is known as the sexual abuse shield rule. Have you heard about that? Sexual abuse shield rule. Like if you ask a question, you may not be permitted to ask the question if it is covered by the sexual abuse shield rule. Objection? Okay, now look. What evidence is not permitted? Well, number one, evidence offered in court to prove the sexual behavior of the alleged victim. It is called sexual behavior. Hello, I'm translating sexual intercourse. I don't know why they are using terms hindi clear ang meaning. But the meaning of that is sexual intercourse. Evidence offered to prove the sexual behavior of the alleged victim. How would you say? In a child abuse case, like rape, and then offered to show that the victim has some sexual encounters in the past. That's not allowed. It can be tentative because you cannot prove the sexual behavior of the victim. And also evidence offered to prove the sexual predisposition. Sexual predisposition of the victim. That is not also allowed. Alright? Is it not a fact, Madam Witness, that in May of last year, you were working as a prostitute, in a nightclub, so that's not allowed. They cannot check. You know what I'm saying, but it involves a case of sexual abuse. Of a child. When you say child, should be less than 18 years old. Child yun. Like if you have a girlfriend who is only 17 years old, your girlfriend is a child. My goodness. You know what I'm saying? If you have a girlfriend who is a child, okay? Exception is there. It's there. That evidence to prove is specific what? Sexual behavior. Of the alleged victim is admissible to show that a person other than the accused is the source of the semen or injury or other physical evidence. Like they found some pieces of evidence as the crime scene, for example. Okay, And then you will now prove a specific act of sexual behavior. Just to show that the accused is not the source of the pieces of evidence. You understand? Then that is allowed. Okay, so sexual abuse shield rule. Exception, all you have to do, or all you have to remember is evidence of a specific act of sexual behavior of the alleged victim to show that the person other than the accused. Like, may natagpuan doon na saliva, ganyan. Or something else. Then you can prove the specific act of sexual behavior. Or then, they always ask something about dying declaration, also known as what? Ante-mortem statement. If they would ask you in the bar exam a question of, the question of, is post-mortem statement admissible? Post-mortem? You know what I'm saying, man? Are you still there? When you say post-mortem statement, it's a statement made by the victim after his death. Post-mortem na. Ang visible ay ante-mortem. Post-mortem, after. May mga ganun ba? Of course. In our hometown, for example, suddenly, this macho man will be shaking like anything in them. Voice will come out from his mouth. It's the voice of a woman. Maganda. Bakit? And then, he will also answer, gano'n. Bumalik ako. Para sabihin ko na gumahasa ba? Maganda. Mag-iba yung boses na gano'n. Sa aming bayan, uso yung gano'n. Ay, tulog na. Uso. Ngayon, iPhone na, yung uso na. Di ba? If I just ask you man, my crazy examiner is post-mortem statement admissible. Suppose that is the question, how will you deal with that question? I'll tell you ito. If what is meant is ante-mortem statement, then my answer is, yes, it is admissible. Yeah. This is crazy. This is absolutely crazy. I'm very cautious, very polite. If what is meant is ante-mortem statement, not post-mortem statement, then my answer is as follows. Very cautious, very polite. Come on. That's how you deal with a question like that. Now, take note that this ante-mortem statement is admissible. It's made by a declarant under the consciousness of what? Impending death. You don't say under the consciousness of death. You know that? It should be under the consciousness of impending death. Yeah. Bakit naman nandiyan yung word na impending? Because tayo naman, every now and then, we become conscious of our own mortality, di ba? And then we say, like in my case, I tell my wife, if I die, no. If I die, I should be buried in less than 3 days. Yung sabi mo sa wife mo gano'n. I am making that statement under the consciousness of death. And that will happen probably after some 25 years. I am now going 64, not 25. My goodness, I will be 89 when I die. But I'm making those statements under the consciousness of this. But that's not what we have in a dying declaration. The declarant must make his statement under the consciousness of understanding this. And then this statement is offered as evidence in any case. Look at that, in any case. Like civil case, yes. Like criminal case, yes. Like administrative case, yes. The rule says in any case in which the rest of the declarant is the subject of inquiry as evidence of the cause and circumstances of the death. That's why, to be a dying declaration, the declarant must die. So it doesn't, you must die, huh? You understand? Let's say that he made a statement under the consciousness of an impending death, but he never died. Is that admissible as a dying declaration? No, because in a dying declaration, the subject of inquiry should be the death of the declarant. So if he does not die, what death are we talking about? Diba? Admissible in any case. But to be admissible, the statement must be complete. By the way, suppose, in one case ba, tinanong yung tao na biktima ng sakta. Kaya mo pa ba? Baka hindi na. Pwede ka pang madala sa hospital? Siguro. My goodness. Maybe. Yeah, sa English, maybe. Then it was held that the declarant is under the consciousness of an impending death. But if it says, kaya mo ba? Siguro. 5 saksak lang. Hindi mo kaya? Kaya rin mo. Sino ang sumasak sa'yo? Si Abe. And then, he died. Question. Is that admissible as a dying declaration? No. Because when he made it, he was not under the consciousness of an impending death. By the way, why is it admissible? What did the Spirit say? Because of the common belief that a person who is dying is already incapable of telling a lie. Kung namamatay ka na, you're now incapable of telling a lie. Yun ang kasabihan. Kaya kung born liar ka talaga, hindi ko yan. You lie even, are you going to die? Hindi. Sunod pumatay sa'yo. Kung feel yun, tingnan na. Sunod. My God. Okay. Ngayon, what did I say? I said that to be admissible, the statement must be complete. If incomplete, it is not admissible as a dying declaration. Yeah. Like in one case, ang tinanong sa biktima, as testified through by the witness, ito. What happened? Kung tanong niya sa sana, sino ang tumaktak sa'yo? And then he mentioned the name. Si Abe. Yeah. That's complete, di ba? Ikaw nung tanong sa kanya ay, what happened? Ano ba what happened sa Tagalog? Ano ang nangyari? Nangyari. Ano ang nangyari? Ang sagot niya, si Abe. And then he died. That's not complete. Diba? Ano ang nangyari? Si Abe. That's not complete, diba? That's not admissible. In one case, ganun talaga ang sabi ng witness. When you told the witness, what did you ask him? I asked him, ano ang nangyari? Good, sabi niya. And what did he say? He said, si Abe. And then what happened next? And then he died. Did he say anything else? No more. Yeah. Then the report said, that's not admissible as a dying declaration because it is not complete. Understand ba? Ano pa? school namin, we always, may pangalan na standard, no? Kasi kung isipin mo pa yung mga pangalan, it will take time, palaging natin. Lahat ng mga subject, natin. Kaya, there was a problem in the midterm exam. Abe, so. And then the question, is Abe correct? Yeah. Pag, tapos ng isa, the student met. And then the teacher discussed the answer. Kasi yun naman dito sa problem na ito, like so na yun eh. Is Abe correct? Of course, he has never been. He's always wrong. Remember, if it is Abe, always wrong. Alright, Sam? And then find out. My problem naman. Abe. Is Abe correct? Ito naman. Sir, yes. Is this Abe the same as the Abe in the midterm? This is okay. Apa? Oh. Marital disqualification rule. Okay. By the way, any person can testify provided he is not disqualified. And disqualification can be because of mental incapacity, or because of marriage, or because of death or insanity of the adverse party. You call that dead man statute, okay? Or because of privileged communication. Now, the will is done. During the marriage, the husband or the wife cannot testify for or against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal offense. In a criminal case, for an offense to be done by one against the other, or the latter's direct ascendant or direct descendant. You call that marital disqualification rule. Okay? In American law, it is called spousal immunity. So you have to take note also of what it is called in other places. It's called spousal immunity. Yeah. In one bar examination in civil law, they ask a question. What is the doctrine of discovered marriage? You know that? And then, open close. Last clear chance. Sabi kanya, ito, matatanungin yung you know what I'm saying, ba? Like, they would ask, what is spousal immunity? Open close. Marital disqualification rule. You said, di ba? O, pagkakunin mo lang, what is spousal immunity? Ganun ka, wala na yung open close. Okay. Now, here comes in marital disqualification rule. The disqualification is absolute. Okay? Without the consent of the affected spouse, the husband or the other spouse cannot testify without the consent. And it has been said by some textbook writers that you can even silence the witness by marrying her or them. Okay, like, take shot a person, killing him right then and there. The only eyewitness was Beverly. She was the only eyewitness. A woman, about 41 years old. About 40 years old. Okay? And then, a case was filed against them for murder. And the only witness available to testify was the woman. And then 2 weeks before the trial would start, Ed went to the woman. Ma'am, are you single? Yes. Well, I am also single. And why did you come here? To tell you honestly, ma'am, I came here to propose to marry you. Do you love me? Ang totoo ko, hindi. So why are you marrying me? So that you cannot testify in my case. Because, to be honest with you, I like your honesty and yes, of course. So I'd like also to marry you. Because, to cut a very long story short, kasi mahaba yan, they became husband and wife. And then, the trial, on the day of the trial, the prosecution called the woman as the only witness. And then the accused objected. Objection! I am objecting to this witness testifying because she is my wife. I invoke spousal immunity. Sabi ka na. Question. May the woman testify over the objection of the accused? Dr. Clark? No. Yeah, because what? They are husband and wife. That's covered by the marital disqualification for. But well, let me tell you this one. Who can invoke the marital disqualification rule? Who can invoke it? Is it the spouse party or the spouse witness? Can you understand the question? By the way, the spouse cannot object if he is not a party or she is not a party to the case. She can or he can invoke spousal immunity only if he or she is a party to the case. If she is not a party or he is not a party, he, she cannot invoke. Okay? And who can invoke? Well, the one who can invoke it is the spouse party. So if I am being called to testify, I cannot say, I object. The one who can object should be my spouse. You understand? Who can invoke? It is the party spouse. Suppose they would ask you a problem like this one. Here is a case, people versus W, the wife, people of the Philippines versus W, for violation of Republic Act 9165. When the police raided the house of W, they saw in the kitchen 5 packs of dried marijuana leaves. My goodness, 5 times. Okay? So, W was charged with violation of Republic Act 9165. At the trial, the prosecution presented the police officers who conducted the raid, and then it is now the part of W to testify. W is now on the witness stand, alright? Testifying as his own witness, as per own witness. At that time, the husband was there present. And then a question was put to W. How did it happen that there were 5 packs of dried marijuana leaves in your kitchen? And that was, my husband brought them to our house 2 weeks before the raid was conducted. And then the husband objected. Objection! I invoke marital disqualification rule. The question is, may the husband invoke it? No, because he is not a party to the case. So the only one who can invoke this marital disqualification rule is a spouse who is a party to the case. You understand? So the husband cannot invoke it. So, marital, by the way, justice one. Yung physician-patient privilege, alright, that is applicable only in a civil case, whether the patient is a party or not. Teka natin ang MCQ. Applicable in any case. B, in a criminal case. C, in a civil case where the patient is a party. D, in a civil case whether or not the patient is a party. Pwede gano'n ang MCQ. Yes?
Then, yung sabi mo kanina, yung dapat yung testified, yung husband ang nagdala ng 5 lakhs. I-pass forward lang natin, sir. Di ba judicial record yun? During the testimony ng wife, he testified that the husband brought the 5 lakhs of. That is on record, for example, sir. Then, kinatuhan ngayon yung husband. Can the previous statement of the wife be used against the husband who is now charged of the drug theft?
Good question. Can you understand this problem? The problem is, here when it was the third of the wife who present evidence, she said that the 5 tons of marijuana leaves were brought to their house by the husband. And what did you say? He said the husband cannot object because he's not a party to the case. Let us say that eventually there is a case filed against the husband. Eventually, just say, you understand that? And then the question is, may that statement be used against the husband without need of retaking it? No. You do not present the wife anymore. Just that statement, the transcript of personal traffic law. You understand? Well, on the other class, no people that will violate the rights of the accused husband, because the husband is now the accused, that will violate him of the rights to confront the witnesses against him. Because at that time, he cannot cross-examine, because he was not a party. But he became a party in a subsequent case. And then you will now use that statement of the wife against him without presenting the wife anymore as a witness. That's the question. Can that be done? The answer class, obviously, the answer is no. Alright? Okay? Any other questions? Then you must also know what? Marital privilege rule. This applies only to what? To communication made by one spouse to the other during the marriage. But the prohibition applies during or after the marriage. You understand? Like, here is communication between husband and wife made during the marriage, and then the marriage was dissolved. And then all the other parties to testify on the communication. Can you still invoke the marital privilege rule? Yes, because it applies during or after the marriage. But then, the communication must be received by one spouse from the other spouse during the marriage. By the way, question. Does that apply to all communications? Yes. Except those made in public. Like, always another one, in the public market, that's not covered by the privilege because it was, what? It was uttered in a public place. But let me tell you something about it. That communications between husband and wife all communication between husband and wife are presumed to be confidential. So you don't have to prove the confidential nature of the communication. So you don't have to bring a card with you. May card ka niya. Nakasulat ay confidential ito ha. Every time you talk, you show it to your wife. Oh, confidential ha. Oh. You don't have to do that. Why? Because all communication between husband and wife are presumed confidential. Can you understand the implication of that? So I don't have to warn my wife all the time. Huy, may sabihin ako sa iyo. Kaya lang, ito ay confidential ha. Pero, alam mo, narawa ako ng tugal, tapos nagnago pa ako. I don't have to warn my wife. Don't say that to anyone. No, because every communication is presumed to be confidential. Oh.
Yung mga influencer during sa barangay, yung mediation conferences, halimbawa yung sa parin na kapanan sa statement, kung di ba yung mga kapit, maging witness doon sa conference sa iyang statement?
Wala namang sabi dyan there's no prohibition, you know, kaya lang, kung meron ang gagawin ng kapitan, nobody will go to him anymore, you know. Kaya lang sa mediation, do you know mediation pa? Court, annex, mediation, you know that? Anything that you say is confidential. And it cannot be used for or against you. Yeah. So, mediation. Alright? By the way, I always tell my class, if they would ask you what are the modes of alternative dispute resolution. Have you heard about that? Of course. Then you say, the following are the modes of alternative dispute resolution. 1, mediation. 2, arbitration. 3, conciliation. Number 4, mini trial. And then number 5, early neutral evaluation. If they would ask you, give 6, then you say number 6. Any combination of the foregoing, like mediation, arbitration, any combination of the foregoing. That's number 6. If they ask you, give 7, then you say, number 7, another combination of the foregoing. Kaya kasi nagulong mo na siya, hindi? Early neutral evaluation. Neutral meaning trial. Meaning, again, M-I-N-I. Alright? Pagkakatakin niya, kasi biglang-biglang pumasok sa ulo natin eh. Kaya, pagkakatakin niya. Alright? So these are the modes of alternative dispute resolution. Although the rule does not prohibit any other mode based on tradition or custom of the place. Yeah. You know, I had a classmate who became a judge in Ibugao. Alright? And then he was published in the Daily Inquirer one time, very long ago, because of what today. There was this case involving a land dispute, okay, in their hometown, and the case has been there in his courtroom for a long time. And then he decided to end the dispute by calling the elders, okay, and then they agreed on settling the dispute, the case, based on custom and tradition. So the plaintiff, they were chanting, Kanya we call it, and then the plaintiff selected his wrestler. And then the defendant also selected his own wrestling. And then they will stay right in the middle of the disputed property. And then there will be wrestling. And then if defendant wrestler, for example, will fall on a certain place, or the plaintiff wrestler will fall on a certain place, that will be the new boundary line. You understand? Good. That was how we did it. And I was very happy when I read his name in the Daily Inquirer because he was my classmate, you know. Somebody asked me, is that valid? Can you obtain the result of the wrestling match? Then my answer is, that is valid, and you cannot obtain the result of the wrestling match unless you can show that there was growth. Like a night before the wrestling match, somebody went to the house of the defendant wrestler with an envelope, for example. You know what I'm saying? And then sabi, oh, wala magpahala na naman. Yung una, nalawan ka din ng sponte. Pero huwag ka mo manunod ko, ito yung envelope. Yeah. If you can prove that, then you can verify the result of the wrestling match. Otherwise, it should be valid. Well then, go back. Go more. Well, you know, somebody told me one time, one Sunday morning while I was inside our church, the pastor said, of course, the way you start is important. But more important is the way you finish. Yeah. You know what I'm saying, class? So on Sunday, this is your chance. And just go there believing in your ability. If you cannot even believe that you can do it, there is no point. Diba? So when you go there, you must believe in your ability. You must finish it and finish it well. Nobody remembers the loser. They only remember the champion, the winner. And all of you have been champions. God bless and thank you.